Me, Andrew, Elliot, Logan. Exactly. Yeah. Miles.
But I only have paper, so I feel like it's okay. Reasonable.
Testing 1 2 3. Testing 1 2 3. Testing 2 3.
Yeah.
Honorable judges of the United States Court of Appeals in and for the Seventh Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as this court is now sitting. God save the United States and this honorable court. Please be seated.
Good morning, everyone. Our first case for argument this morning is United States against DeAndre Maxwell and Tyrone Fulwilly. Mr. Roy.
Thank you, Judge. Good morning. May it please the court, opposing counsel. My name is Michael Roy on behalf of appellant DeAndre Maxwell. This court should vacate the defendant's convictions and remand for further proceedings. I plan to focus on the arguments raised in Maxwell's briefs that the district court applied the wrong burden of proof at the pre-Franks hearing and that it erred when it refused to consider any information about the confidential informant. However, I'm also happy to answer any questions about the pretrial proceedings in general, as Maxwell did join Mr. Fulwiley's arguments about probable cause in the Franks hearing. So to start, I want to focus on the pre-Franks hearing. The standard for getting a Franks hearing, a full Franks hearing, is just a burden of production. It's really about the defendant making a proffer. And then any argument about whether they actually can prove a violation is reserved for the Franks hearing itself. And here, the district court conflated the burdens of proof from the pre-Franks standard and the Franks standard. And we know that because the court said that Franks hearings.
What did the judge apply the wrong standard? What's your best evidence that the judge applied the wrong standard? I know he stated the wrong standard, no doubt, but in his written order, he wrote the right standard.
And I agree. It's important whether he actually applied it too. If he had just misstated it, then there would be a lot more credence to the government's argument that it was a brief verbal misstep, right? However, I think the biggest evidence that he also applied the wrong standard is that he repeatedly drew inferences in favor of the government instead of in favor of the defendant. And I think big picture, the point here is it's a rough analog, not a perfect analog, but I think it's sort of a rough analog to like summary judgment in a civil case, in that there's multiple inferences that can be drawn from the evidence presented at the hearing. You could draw the inferences that the district court did, explain away any potential evidence from the pre-Franks hearing. But if there is also a reasonable inference in the defendant's favor that points to the possibility of a Franks violation, then that is enough to clear the hurdle and get a full Franks hearing. And when a case like this, where probable cause rises and falls with a single informant, evidence that that informant is biased or lacks credibility is enough on its own to get to the next step and get a full Franks.
Why do you say that? So I was going to ask you about harmless error. Why do you say credibility of the informant?
Sure, because I think that looking at the affidavit, the rest of the information in the affidavit that goes towards probable cause, none of it on its own would be enough to support probable cause.
Collectively.
I think collectively, if everything from Kirk was removed from the affidavit.
Your argument is there's no problem. No,
I'm not even sure that the government argues that if you remove all of Kirk's statements that there is still probable cause. Because without Kirk, it's, even though we're arguing that Kirk's statements are still too conclusory, lacking in detail, the other evidence or statements in the affidavit are extremely conclusory. It's stuff like.
Don't you still have a good faith problem?
Well,
Even if you're right on all of that, do you have a good faith problem?
Not for the Franks arguments, because a Franks violation gets past good faith. For the probable cause argument raised in Mr. Fulwiley's brief, we would say we get around the good faith issue by being able to point to Bell, this court's decision as Bell, as an analogous affidavit, another case that failed probable cause.
Mr. Roy, on the Franks issue itself, what's the material omission in the affidavit, or omissions plural?
It's the information that leads to either Kirk having biases or just physically not being able to observe the conduct he did.
But in the affidavit itself, it states that Kirk lives near apartment 209, and the confidential informant Kirk then appeared in front of the issuing judge, right? And by appearing in front of the issuing judge was able to answer any questions the judge would have had about what living near apartment 209 means. Why isn't that enough to save the affidavit?
Well, in this case, there's no evidence that he actually like went under oath while before the issuing judge or testified. It just says he was there. As this court explained in Glover, without evidence that he actually testified, the assumption is he did not testify. He did swear to sign the affidavit, but there's no evidence the judge did ask any questions. I mean, it's possible, but it's just not in the record.
Wait, why would we want the judge asking questions that are not in the affidavit? Once he swore to the information in the affidavit, that's it. Why
Well-
is that not enough?
I mean,
Why does the judge have to ask questions that go beyond the information that's in the affidavit?
the judge does not have to in every case, but it's something the judge can do to sort of bolster the affidavit. And it's a factor, one of the 5 factors on informant-based affidavits that can increase the credibility of the informant, increase probable cause, is if they not only appeared before the judge, issuing judge, but also testified and answered questions. It's sort of like a belt and suspenders thing a judge can do.
It doesn't have to.
No, we're not arguing the judge has to do that in every case.
So I don't understand, I'm not sure I understand what you're saying. So if we assume that the confidential informant went with the detective to the swearing out of the search warrant, you're saying we should not further assume that the state court judge was able to answer or able to ask a question about an ambiguity in the affidavit without affirmative evidence of that?
Well, I'm sure the judge was able to. I mean, the judge, of course, could have
Why
done
isn't
whatever
that
the power,
enough?
but there's no evidence that the judge did do that.
Because maybe the affidavit was fine.
Well, and apparently that's what the judge thought also. And this is only one of the 5 factors that goes towards probable cause. It's something that could elevate the affidavit if the rest of the factors fell short. But our argument is the rest of the factors fall short and that this additional factor, which could have helped the government, is absent in this case or not fully there.
There's corroboration in the warrant application from the interview with the property manager that bolsters what the confidential informant was saying in the affidavit, which would have given the issuing magistrate or issuing judge some confidence that there was no need to put the informant under oath, bring in a court reporter, have a testimonial warrant application as opposed to just a paper warrant application that's sworn.
Sure.
Typically, that's what would happen if the judge has questions that about the 4 corners, what's in the 4 corners of the warrant application. Convenes an on-the-record proceeding and asks questions of the officer and the informant.
And I would push back a little that the property manager complaints are corroboration, because really all we know is a property manager said that, yes, some people complained that there might be drugs, right?
At that apartment.
Right.
Frequent multiple complaints, I think.
Well, we don't even know how many complaints. We know that the carpenter, the detective, talked to the property manager close in time to asking for the warrant, but we don't know when the complaints were made to the property manager. Also, this is like heavily student housing, so presumably a lot of people are on year-to-year leases. That's, I mean, there were multiple people who were interviewed in this case who were tenants who had moved in the summer, which would be expected if they're on an academic calendar. We have no idea even when these complaints were made to the property manager. We don't know what the substances of what's them. I mean, I think one thing that's notable is Kirk, a big part of his was like, well, I smelled marijuana. I think
You
they're
also
dealing.
got the criminal history.
Sure.
Right? I mean, that's not nothing.
It's not nothing, but I think it barely moves the needle. I mean, criminal history in and of itself is not indicative of criminal activity.
How that weighs in considering the other evidence in the totality.
I mean, I think it can be relevant, but it's sort of fall back to if you remove all of Kirk's statements, which is what they were challenging with the Frank's motion, saying that they have previous criminal history does not raise them to the level of probable cause. Kirk's statements in the affidavit are absolutely necessary for probable cause.
Just to, again, confirm the universe of omitted information, according to your Frank's argument, it's the lack of vantage point, the informant's lack of vantage point about what was going on in the
And-
apartment, the physical issue.
That's half of it. The other half is the potential biases of it, in that the investigator identified BF as the presumptive person who was the informant, who had another tenant said BF had been bragging about getting rid of tenants and threatening to do it again. He said he did not like those tenants because of noise complaints. So there was, we don't know exactly, because then the district court sort of put the kibosh on putting any evidence in about BF or about Kirk, which dovetails into our other argument about the confidential informant disclosure, although I see that I remember.
Well, go ahead, you can say a few things about that issue.
Sure. So regarding the confidential informant, obviously the ultimate decision on whether to disclose is normally abuse of discretion. But in this case, I think there's two clear legal errors that require at least a do-over.
And this, for the students, is disclosing the identity of the confidential. informant.
Exactly. Yes.
Thank you.
Yes. I apologize. I'm not entirely speaking for the student audience.
Understood.
So the first legal error is I think the district court applied sort of a bright line rule that tipster means no disclosure. The next legal error was also assuming that it can't be relevant if he doesn't have trial relevant testimony. Both those are just legally wrong. It's a balancing test. Tipster status puts the weight on the government side, or adds some weight, puts a thumb on the scale, but it doesn't automatically mean no disclosure. Likewise, it doesn't have to be a trial witness. At a Franks hearing, it's crucial if you have evidence of bias or evidence of anything that draws into question the informant's testimony. And this court very frequently sees Franks type claims that are all about this confidential informant has these credibility problems that weren't part of the warrant. Taylor, Clark, and Glover are examples of that exact fact pattern. That's just drawn from cases we were already citing in our briefs. Then I think to compound it further is, even if the court had grounds to initially deny the motion to disclose, and we're not even arguing that like he had to grant disclosure, just that he applied the wrong legal standard. When it came to the hearing itself, he should have allowed the defendants to present their own evidence. That's separate than the government's privilege against disclosure. Does not mean that the defendants are also barred from presenting their own evidence about the informant or potential informant. And it sort of begs the question, who exactly are we protecting from learning about the informant's identity? The government knows who the informant is. The defense presumably knows who the informant is. They're trying to present that evidence. It's only the district court who doesn't know. So what exactly is the public policy benefit of preventing the defendants from telling the court? And if the issue is that the transcripts are going to get out or something, there's alternatives. It could be in-camera review. It could be sealing portions of the transcript. But if we're just protecting the district court from learning the informant's identity, I would presume the district court's not going to go out and do anything to the informants, right? That's not what the public policy is about. I'm happy to answer any specific questions, though, about the confidential informant.
Thank you.
All right, thank you, Judge.
Ms. Chakron, is that how it's pronounced? Chakron, okay, thank you.
Good morning. May it please the court. Opposing counsel. Carly Chakron on behalf of appellant Tyrone Fulwiley. There was insufficient evidence to prove Mr. Fulwiley guilty of possession of the drugs with intent to distribute, with possession of the firearms, or with possession of the firearms and furtherance of a drug trafficking offense.
What about the baggies of drugs in his bed?
There were bags of cocaine found in the south bedroom, but there was not a substantial connection to connect Mr. Fulwiley to the south bedroom.
What about the stuff that belonged to him that was in?
The government presented two pieces of evidence that belonged to Mr. Fulwiley in the bedroom. There was a 2018 MoneyGram, and there was a debit card on the floor. We have absolutely no idea. There was how long those pieces of evidence were in there. No evidence was presented how long those documents were in the south bedroom.
In the lease?
No, Your Honor.
Does he dispute that he lived in the apartment?
We dispute that Mr. Fulwiley lived in the apartment in 2021. It's unclear as to when Mr. Fulwiley actually may have lived in the apartment, Miss Lori Wilson testified at trial that she had subleased the apartment to Mr. Fulwiley, but her testimony was pretty hazy as to specifically when. She said she had signed the lease at the end of 2020 and within a month or two had subleased the apartment to Mr. Fulwiley. As you noted, there's no lease, there was no documentation. It was a very loose sublease
Why is
agreement.
that not enough for the jury with the other?
Sure, Your Honor.
You know, I mean, putting him in the apartment, start with that.
Sure. So there's no definitive evidence putting Mr. Fulwiley in the apartment in 2021. And to prove possession of those drugs, the government had to prove that Mr. Fulwiley possessed the drugs that were found in the apartment that were seized during the search warrant on September 29th, 2021. There's absolutely no evidence there's no testimonial evidence placing Mr. Fulwiley in the apartment. Ms. Wilson could not place Mr. Fulwiley in the apartment in September 2021. And then the government's other witness was Daniel Walls, who was a resident at the apartment. He could not place Mr. Fulwiley in the apartment at any specific time, including in September of 2021. So the government failed to prove a substantial connection between Mr. Fulwiley and that south bedroom. So then the last piece of evidence the government really hangs its hat on is the DNA profile that was found on the two firearms. So after the search warrant, execution, there was two firearms found in the apartment. One that was found in the north bedroom that belonged to Mr. Maxwell. There's I don't believe there's any dispute that Mr. Maxwell resided in the north bedroom. The other firearm was found under a couch cushion in the living room. The DNA profile contained Mr. Fulwiley's DNA plus 3 others. The government's expert at trial could not testify or could not tell us when that DNA was got onto the gun, so how long the DNA had been on the gun, or if the DNA was directly put on the gun. He testified that DNA could be transferred. So at most, the DNA profiles on the two firearms show that some point in time, unknown point in time, Mr. Fulwiley may have touched the guns. Mere touching is not dominion and control. The government, it shows at most that he had access to the guns at some point, but it does not show that he had dominion and control. And
Do you have any case law support? Felon touches a firearm, or felon comes in contact with a firearm that the felon does not possess the firearm?
yes, Your Honor, United States versus Katz is instructive here. In that case, the defendant was convicted of unlawfully possessing a firearm by a felon. And in that case, the main evidence against the defendant was his fingerprints on that gun. At trial, in that case, the expert testified that they could not tell how long those fingerprints had been on the gun.
That's different. That's a timing issue. That doesn't say that if a felon possesses a gun, he actually doesn't possess the gun. In other words, if you're a felon and you pick up a firearm, that is a crime. Full stop.
I would disagree with you, Your
How
Honor.
so?
In that case, this court said that the fingerprints only showed that at some point that defendant had touched that gun, and that
Not whether if he possessed it after he did the felony, that's a violation of the.
but in order to show the possession, the government had to show that the defendant had the power and intention to exercise dominion and control, and that is not what we have here. And that just like in that case, the government did not prove that that defendant possessed the gun. Mere touching of a gun is not possession. It may show access, but access is not possession. Because
Could You can be convicted of felony.
Yes, Your Honor, that's true. So
How can you be acquitted? Tracking that.
just because mere touching is not dominion and control. So I guess we'll go by a hypothetical here. If let's say Mr. Fulwiley, there had been evidence that presented at trial that someone had seen Mr. Fulwiley with a gun, or someone had seen Mr. Fulwiley using a gun to protect himself or protecting his drug. There was none of that. That would potentially rise to the level of constructive possession. But that's not what we have here. We just have the DNA profile, which we do not know how long it's been on there. And also the indictment charged Mr. Fulwiley with possession between the January 1st, 2021 and September 29th, 2021. But again, there's no evidence that the DNA profile we have no evidence as to when the DNA profile was put on the firearms.
I thought one of the neighbors, this guy named Daniel Walls, testified that Fulwiley was one of the apartments, was someone who lived in the apartment.
Yes, Your Honor. Mr. Wells did testify that Mr. Fulwiley was a resident of apartment 209, but again, he could not specifically place Mr. Fulwiley in the apartment at any specific time, especially, he said back in 2021. That was as much as he could say. He testified that he could not place Mr. Fulwiley in the apartment in September of 2021 or in August of 2021.
And the standard of review under which we're evaluating this is awfully deferential to the government side. Circumstantial evidence we know is allowed to prove each of these crimes. And we've said it's a nearly insurmountable hurdle
Yes, Your Honor.
to beat a jury verdict on insufficiency grounds.
Yes, Your Honor. It is a high burden, but the height of that hurdle depends directly on the strength of the government's evidence. And here, the government's evidence is thin. I'd like to save the remainder of my time for rebuttal.
That's
Thank
fine.
you.
Thank you. Ms. Boyle.
Good morning, Your Honors. May it please the court, counsel. My name is Catherine Boyle on behalf of the United States. Your Honor, there's a number of issues that have come up with both of my co-counsel of both opposing counsel today, and I'd like to start with the search warrant itself, since sort of looking at whether the search warrant affidavit had probable cause is an underlying issue for a lot of the other things going on here. If you look at the affidavit in this case, the information within the four corners of the affidavit provides ample probable cause, examining the totality of the circumstances, which is the correct standard. As Your Honors noted earlier in speaking to opposing counsel, the correct standard here is not breaking everything apart and seeing if every individual piece itself would supply probable cause for this search warrant. The correct standard is looking at everything in the affidavit and seeing how it adds up. In this case, you have the confidential informant's information, and you also have substantial corroborating information. One of the things you look at when you're evaluating a confidential informant's information is level of detail and firsthand observations. Here we have detailed firsthand observations of drug trafficking. We have somebody who lived near apartment 209. Over the course of the year, they've seen two men who they describe specifically in their 30s who were the only apparent residents of the apartment. The confidential informant provides information that on multiple occasions a week and often per day, he sees the men conducting what appear to be drug transactions, hand-to-hand exchanges, and observes brief visits to the apartment, which is also consistent with this sort of drug exchange. The confidential informant had smelled fresh cannabis emanating from the apartment within the prior week. Within the past 6 months, he saw one of the residents with a gun in the waistband and provided a description as to which resident it was. The confidential informant was able to locate the suspected drug dealer's Facebook profiles, which permitted law enforcement to check the photographs on those profiles and note the vanity names that were associated with them. The confidential informant ID'd Mr. Fulwiley and Mr. Maxwell from Illinois Secretary of State photographs. If you look at the degree of corroboration here, you also have the Crime Stoppers tip. You have the property manager, as Your Honors noted, who said that person had received multiple complaints of drug dealing The property manager didn't say exactly when that occurred, but she was interviewed within the week prior to the search warrant. It was quite recent. She also explained that the female lessee of the apartment was not staying there, that maintenance men had seen 2 black males staying in the apartment, which also fit with Mr. Fulwiley and Mr. Maxwell's description. We discussed the Rantoul, Illinois traffic stop of Ms. Wilson's car, the discovery of drugs, the potential association with the vanity names of the defendants that were later discovered via the Facebook profiles and various aliases in criminal cases. And you also have the criminal histories of the defendants themselves. They were convicted of a federal drug conspiracy in South Dakota involving the exact same drug that they were dealing again in this case.
Ms. Boyle, Mr. Roy makes some points about the importance of the informant in the grand scheme of the affidavit, and also emphasizes that what's really important here is what does it mean to live near apartment 209, given the layout of where 209 is at within these Park Place apartments? How do you respond to those points that he's made, that there's really without more information in that affidavit about what it means to live near that apartment, given the layout, there's just really no way to say that the confidential informant Kirk was in a position to see this activity.
I understand, Your Honor. First, I'd just like to step back and make a point about the general assertions about the confidential informant here in the Franks hearing, which is Mr. Roy suggested that in order to examine whether the informant's statements were material here, you would have to take them out entirely, but that's not what was talked about below. We talked about whether adding certain items regarding the view that the confidential informant could see from their apartment would change sort of the analysis of the affidavit. In this case, as the district court noted, the district court found correctly that they could have seen, the confidential informant could have seen the drug transactions outside the apartment as well. So whether the confidential informant is seeing these drug transactions actually at apartment 209 or potentially outside the apartment building, but knows that the residents conducting them live in apartment 209, both of those things here would support probable cause in the affidavit, regardless of which way you interpret it. So even if you take the defendant's position into account and say, this person did not live on the second floor, for instance. So their real view here was to the first floor and the door. This is also not a big apartment building. There's about 8 apartments in it entirely. This is during COVID. Everybody is home. Everybody knows exactly where people live. And they know if the defendants are returning to apartment 209 after conducting these hand-to-hand transactions in these very short visits.
Don't you think that the information in the affidavit from the informant about living near 209, at least as conveyed to the issuing judge, were observations about what the informant saw or heard or smelled coming from 209? In other words, it's very hard for me to read that and think, well, there was drug dealing going on in the parking lot, or there was drug dealing going on out back. I read what's in the affidavit as the informant saying, no, I have firsthand knowledge about what I believed was going on either in or at the doorway of apartment 209.
I actually don't think it's that relevant to that analysis, whether the informant lived on the first or second floor. Just because the informant potentially lived on the first floor or lived on the second doesn't mean they couldn't see what was going on either other floor. This was a small apartment complex with an open stairwell. And I don't think that we need to, I think that even if we were to assume that the confidential informant's statements were regarding what was going on in the apartment building, we would not necessarily have an issue with the exact which one of the 8 apartments or so in the building the confidential informant lived in. I think that all these observations probably could have been made by somebody living on either floor. Just to go back a little bit to the affidavit itself, the time between the events reported in the warrant application was recent, as we discussed in our brief. And very importantly here, this is a confidential informant who went with Detective Carpenter before the issuing judge, appeared, swore to the statements. That adds an incredible additional level of reliability to the informant's statements here. And as your honors noted, this is a situation where when you look at the contents of the affidavit, good faith would apply. I understand that goes to the Franks allegations as well here, of course, because you wouldn't have good faith apply if there was something included that was in reckless disregard for the truth. But the district court didn't err here, clearly or otherwise, in denying the defendant's motion for a Franks hearing. The defendant simply did not make a substantial preliminary showing that the warrant application contained material omissions that would alter the issuing judge's probable cause determination, and that those facts were omitted intentionally or with reckless disregard for the truth. They cite Mr. Moody's testimony and interviews with apartment building residents and say that what he discovered would have raised questions about the confidential informant's reliability and credibility and altered the probable cause analysis. The allegations, as your honor noted, are that only one apartment had a direct line of sight to the front door and no first floor apartment had a direct line of sight to the second floor, and that only one resident suspected drug dealing activity. But even if, as the district court found, even if you include all that information in the affidavit and make these suggested excisions, you're still going to have probable cause, because when you look at the affidavit with those changes, you have multiple tenants complained to property management regarding suspected drug activities at apartment 209. You have one tenant also complained about noise from that apartment. Maintenance workers confirmed that 2 men, rather than the named tenant, were residing at the apartment. A Rantoul Police Department investigation connected those residents to the aliases Ben Frankline and Socks, and the Facebook profiles with those same aliases matched photographs and other identifying information for the defendants. Kirk observed a suspected drug activity outside the apartment by 2 men Kirk knew as apartment 209's tenants. Kirk detected the fresh scent of cannabis in the week prior to the execution of the warrant, before the warrant's issuance, and Mr. Fulwiley and Mr. Maxwell were previously convicted. If you put all those things together, that takes into account every suggested change that the defendants mentioned below, you would still have an affidavit that supplied probable cause in this case. There's also no evidence here that any purported facts were omitted intentionally or recklessly. And there's no evidence that the confidential informant's identity would have changed the calculus. It's simply not material in this case. Regarding the potential viewing of drug transactions outside or at apartment 209 itself or at the threshold of apartment 209, the issuing judge for the search warrant could draw reasonable inferences that the men were dealing drugs where they lived. One point I wanted to make that I think is important here is I think, first of all, we have a situation where admittedly there was a verbal slip at the pre-Franks hearing in terms of what the legal standard was for, but that's something the district court corrected in both of its written orders on this case. The district court used the correct standard. And one of the other criticisms the defendants make here of the district court in an effort to show why potentially these rulings were incorrect is they criticize whether the district court could look at all at how likely something was to happen. And I think an interesting analogy here would be how an issuing judge might evaluate a probable cause analysis. That issuing judge, in evaluating whether there's probable cause for something, does not have to refrain from considering whether it is vastly more likely that another possibility would occur. And so too here in looking at the pre-Franks analysis, the judge is permitted to think about a relative likelihood when they're evaluating the substantial preliminary showing. Turning quickly to informant identity, the district court here acted well within its discretion in upholding the government's privilege to withhold the identity of its confidential informant. Although the defendants claim in this case that the district court just applied a bright line rule and confined its analysis to whether the informant was a mere tipster or was a transactional witness, that's not the case. It is true that the district court said that the informant, correctly said that the informant was a mere tipster, but the district court also said that the defendants hadn't established a need for the identity in light of that, and that's true here. There's no need to have the confidential informant's identity in this case. And that's important because we, as a society, generally, we want to encourage individuals to report crimes to law enforcement. And one of the ways we can do that is by not necessarily, is by creating sort of a presumption, subject to exceptions, that their identity will not necessarily be revealed for doing so in a situation where they're a mere tipster and they're not involved in the transaction. Looking at the sufficiency of the evidence, ample evidence supported the jury's determination that Mr. Fulwiley was guilty of all 3 counts. As your honors noted, the standard here is viewing the evidence in the most favorable light to the government, whether any rational juror could find that the defendant was guilty of these crimes. In terms of the defendant's drug possession, which could be constructive here, it is clear that there was sufficient evidence for a reasonable juror to find that the defendant possessed these drugs. As your honors noted, there was cocaine in the defendant's bathroom, the south bathroom, and it's important to think about the layout of the apartment here. The south bathroom and the south bedroom were sort of their own ensuite in the apartment. So when you have this cocaine in the vanity bathroom drawer, and you have Mr. Fulwiley's identification documents in the bedroom, you have evidence from Mr. Walls that Mr. Fulwiley is still living in the apartment. You have evidence that he's been paying cash rent to Ms. Wilson since late 2020, and through the warrant's execution, he's paid up. There's plenty here for a rational juror to draw the inference that A, Mr. Fulwiley lives in the apartment, B, he is a full participant in the drug dealing that's going on in the apartment. For the same reason, we believe there's sufficient evidence of the gun possession. Mr. Fulwiley's DNA was on both guns. As to the gun's specific locations, we would dispute that these guns weren't readily accessible. These guns appeared to be placed just to be readily accessible near to where a lot of the drug dealing was going on. If you look at the layout of the apartment again, one of the guns was in the north bedroom and one of the guns was in the living area under a cushion. Both of these are very close to the door of the apartment where somebody would potentially come in if there were to be a robbery. And they are also very close to the kitchen of the apartment, which is where a lot of the drugs were stored. In fact, the biggest amount of drugs in the contained container that was over 40,000. For the same reasons, when you combine all the evidence on the 922G and the 841 counts, you can also see that these guns were clearly used in furtherance of drug trafficking. This is a situation where the apartment was essentially awash in drugs. There were drugs in basically almost every room, and the guns were readily accessible. As the government's expert testified, these were a tool of the drug trade, and you can see from the evidence presented in this case that there was sufficient evidence on the 924C count as well. Thank you, Your Honors. If you have no further questions, we'll rest on the arguments in our brief and ask that the court affirm.
Thank you. Mr. Roy? All your time, but you can have an extra minute in rebuttal.
All right, thank you, Judge. I want to use my rebuttal time to quickly go back to a question Judge Kirsch asked at the beginning about what evidence there was of the district court actually applying the wrong standards in the Franks ruling. It's, I think, the clearest examples of him drawing the inferences in the government's favor, impermissibly so, is first on page 108 of the joint appendix. In response to the defense's evidence that other tenants in the building had been interviewed, had not seen similar activity to Kirk, the court's response was, well, they had just moved in about a month or so before the warrant was sought. Maybe they're too new to know everything. Perfectly reasonable inference. However, an equally reasonable inference is that they didn't see it because Kirk lied or exaggerated. And at the pre-Frank stage, the court should have been drawing the inference in the defense's favor, not in the government's favor. I think the other best example is on page 110, sort of in response to the general materiality issue, saying Kirk saw drug activity outside the apartment building. That's a possible inference that could have happened, but it doesn't say in the affidavit that he saw it. That's drawing an inference in the government's favor. I'd also point at the top of page 110 where the district court is referring to how the issuing judge can draw reasonable inferences about evidence in the government's favor. Definitely true for an issuing judge, not true for the district court when they're deciding a Franks motion. Contrary to the government, I do not think that an issuing judge's analysis of probable cause is analogous. Rather, it's whether the evidence as a whole at the pre-Franks hearing suggests the reasonable possibility of a violation. Unless there's any further questions, I'll sit down. Thank you.
Thank you. Ms. Shokran, anything further?
Yes, briefly. The evidence showed that Mr. Maxwell was dealing drugs from this apartment. that Mr. Maxwell was using firearms in furtherance of a drug trafficking offense. Again, there was no evidence that tying Mr. Fulwiley to the apartment, to the drugs that were found in the apartment on September 29th, 2021, to the guns, and there was even less evidence tying the firearms to the drug trafficking offense under 924C. The government had mentioned that there was evidence that Mr. Fulwiley was paying rent through the time of the search warrant. That's not what the evidence showed. Ms. Wilson testified that she had only collected a couple months of rent, and that was at the very beginning. There was no evidence showing that Mr. Fulwiley was still leasing the apartment through the time of the search warrant. So we would ask that this court vacate and reverse Mr. Fulwiley's convictions. Thank you.
And thanks to all counsel. We'll take the case under advisement. Move to our second case this morning. Alan Braid versus Oscar Stilley. Before we begin with this second argument, we'll take a brief recess. All right, again, our second case this morning is Alan Braid versus Oscar Stilley. Mr. Franklin, good morning.
Good morning, Chief Judge Sykes. May it please the court. David Franklin on behalf of plaintiff appellant Dr. Alan Braid. If I may, I'd like to first address interpleader jurisdiction and then turn to the abstention issue. So as the district court recognized, jurisdiction is secure here because all of the requirements of statutory interpleader have been met. There's minimal diversity among the claimants. The claimants are adverse because only one can collect on a judgment. The amount in controversy, of course, exceeds $500, and Dr. Braid has deposited the disputed amount with the district court. Now, Amicus argues that there is no limited identifiable fund here, but that's not true. The $10,000 that was deposited by Dr. Braid is the amount that must be awarded to a successful SB8
Can
plaintiff.
they get more?
They could conceivably get more, but that doesn't mean that the interpleader plaintiff has to deposit more in order to trigger the jurisdiction of the interpleader court. What needs to be deposited is the amount that is disputed among the claimants.
Well, if it's more, but if they could get more, why isn't that disputed? Especially if one of the claimants asks for more.
Right, but
You know, one of the claimants says, I want $100,000. The doctor deposits $10,000. Why is that enough?
because the disputed amount is the amount that all of the claimants have claimed an entitlement to here. And here we have Mr. Gomez, who didn't ask for any damages because, but nonetheless, under Texas SB 8, the court is required to award the $10,000. We have Mr. Domino, who said, I want $10,000 and no more. And yes, Mr. Stilley, who asked for more. But you know, the analogy that we make in our brief, I think it's a good one, is to an uncertain inchoate claim for attorney's fees. That does not have to be part of the deposited amount in order to invoke interpleader jurisdiction, even though it could conceivably be at issue in a state court proceeding or in the interpleader proceeding as well. So Dr. Braid has followed the text of the interpleader statute to the letter. Amicus tries to paint this, I think understandably for his side, as an unorthodox, unconventional use of interpleader. But what's really extraordinary here is not the use of interpleader, but I would submit what's extraordinary is SB 8. It's a statute that intentionally is designed to expose defendants like Mr. Braid to multiple, duplicative, adverse claims with no way to resolve them in a single forum because of the anti-transfer provisions.
Why can't he resolve it? But then, I mean, the bottom line is, why are you in federal court? Why can't all this stuff in Texas?
Because SB 8 in multiple ways confounds the ordinary process of adversary testing and litigation. So, as we've already said, it invites a potentially infinite set of plaintiffs.
Federal and in state.
Right, but in the federal interpleader court, under the interpleader statute, the court can assert jurisdiction in a single proceeding over all claims that have been or could be brought by that set of claimants, and has broad injunctive authority to issue an injunction with respect to all such claims. The Texas courts, by design, under SB 8, cannot do that. So a defendant, for example, cannot raise issue or claim preclusion as a defense. A defendant cannot raise dispositive constitutional defenses, even relying on case law that was good law at the time that he took the relevant action that may have later been overruled. We all know what that was in reference to. There is the anti-transfer provision that essentially prevents the Texas courts from consolidating these cases in a single forum without permission of all parties, which is not going to be forthcoming here.
Mr. Franklin, can we go back for just a second to the 13, the interpleader, the statutory interpleader question? And can you focus with us on the first, in his complaint, in his federal complaint, Dr. Braid brings essentially 6 counts. He styles them as claims for relief. 5 of them are various federal constitutional challenges to the restrictions, the limitations of SB 8 as you were just describing. The first of them is for the interpleader relief. If you focus on the first claim for relief and set the 2 through 6 aside, what exactly does Dr. Braid want a federal district court to do with the first claim for relief?
So he wants the court to fully and fairly resolve the entitlement to the $10,000 stake. Of course, his preferred disposition is to get the stake back on the basis either of his constitutional defenses or on another basis. The interpleader court could decide, for example, that none of the claimants have standing under Texas law. So there are other bases upon which he could prevail there. But short of that, Dr. Braid wants this endless potential chain of litigation to be over.
So
right.
in your view, would it be fair to say he wants final dispositive relief as to the $10,000 fund that he's put on deposit, either that he owes nobody 1 penny, that he owes person X 10,000, no more, that liability would be apportioned in some way? All of that he wants resolved by the federal district court?
Yeah, he has his preferences among those, but that's essentially what he's seeking. I agree with that.
Okay. And as we're speaking right now, and I'm going to ask Mr. Paul the same question, what is your understanding of the state of litigation in Texas, at any level of Texas court, relating to the September 6, 2021 abortion that's the subject matter, of these claims that are brought under SB 8?
Right. So the first thing I'll say is it's a mess, right? And that's by design. This is Texas SB 8 in action, right? But to answer your question, so we have the 3 claimants who were interpleaded here. Gomez's original SB 8 action was voluntarily dismissed without prejudice. He then refiled after the initiation of this interpleader action. That refiling was initially enjoined pending the action in federal court. And then after the abstention decision, that injunction was lifted. He then sued again and was non-suited on standing ground. So Gomez is out. However, because SB 8 works the way it does, he could refile at any time. Okay, so that's Gomez. Stilley's original SB 8 lawsuit is still pending. To my knowledge, it has not been served. And Domino has voluntarily non-suited his case without prejudice to refiling. So again, he or anyone else in the world could come out of the woodwork. We referenced in our briefs Mayor Thomason of Big Spring, who has filed a pre-suit petition under Texas Rule of Civil Procedure 202. So that case could ripen into an SB 8 case
Is
at
it
any
accurate
time.
to say there's no, what you might think of as a limitations period or something that would prevent Jane or John Doe from bringing a claim tomorrow?
There's no limitations period that would
relating.
prevent that tomorrow. That's true. That's true.
This is, I think, properly characterized as an unusual use of interpleader, just like SB 8 is an unusual way of enforcing Texas public policy. What's at issue here is functionally a fine for performing an illegal abortion under the Texas heartbeat law. And the enforcement scheme was designed to avoid ex parte Young litigation to bring a pre-enforcement challenge, pre-Dobbs, against this heartbeat law. And so we have an unusual situation where Texas public policy looms large on the abstention question, because ultimately the district court here abstained under an abstention doctrine that applies to declaratory judgment actions, which comprise 5 of the 6 counts in Dr. Braid's interpleader complaint here. So we have to be aware of the real gravamen of what's going on here in deciding this equitable question of abstention, but also the nature of the remedy that you're seeking is an interpleader, which is an equitable remedy. It's statutory and has expanded well beyond, as a statutory matter, well beyond what the equitable doctrine was designed for. So as I understand your, the thrust of your argument is that while this may be out of the ordinary, the whole domain here is out of the ordinary. And so a pragmatic approach to the elements, the statutory elements of interpleader, particularly with respect to the character of this fund, and whether that first, I guess it's the second element, we have minimal diversity here among the claimants and Dr. Braid, but the character of this fund, it's not an insurance policy that's been, policy limits have been tendered to the court, and the court can sort out who's entitled to an insurance policy. That's classic interpleader. This is something very different. It's a $10,000 minimum fine. Let's call it a fine because that's what it is functionally. It's not formally a fine, but that's what it is. It's just payable to a private bounty hunter. The statute in Texas doesn't cap damages, and the argument here by the court-appointed amicus defending the district court's decision is that interpleader should not be permitted to be used to cap damages. So that second element of an interpleader action, that the amount at stake has not been fully tendered to the court, only $10,000, the minimum fine has been tendered to the court. How do we approach that threshold element before we get to the equities and the deference and comity considerations that are inherent in both abstention doctrines that are at issue?
So I do want to get to abstention. I know I'm already into my rebuttal
I'll
time
give you more
here.
time. It's a complicated case.
Right.
It's the federal court's question for the
Right.
students.
So an unusual one.
Very unusual.
I guess what I would say is that this is not an attempt to use interpleader to cap damages. So there could be questions about whether there are additional damages to be sought beyond the $10,000, and your question, Judge Kirsch, went to that to some degree, right? We don't think the court needs to reach that in order to determine that interpleader jurisdiction is proper here, right? We have our arguments that we can make about that, and I can preview those for you if you're interested. But that doesn't go to the question of jurisdiction. So jurisdiction is not only proper here, right? It's actually quite appropriate in light of the purposes of the interpleader statute, right? The interpleader statute represents a congressional policy that comity concerns have to give way when you've got multiple adverse claimants from different states, right? Minimal diversity, but it's an interstate matter, right? Who are fighting over a common fund, all right? And interpleader cases inherently involve federal courts deciding state law issues, at least since Erie, that's what they involve, right? That are raised or could be raised in state court. And yet Congress has continually expanded the availability of interpleader to resolve those kinds of adverse claims. And the Supreme Court has repeatedly said that the interpleader statute and rule need to be construed broadly. So yes, I don't take issue with your description that this is both an unconventional use of interpleader and a very unconventional state statutory scheme. But I would just add one gloss on that, which is that in light of that unusual state scheme, It's actually a paradigmatic application of what interpleader was designed by Congress to do. And with that, I'll reserve whatever time
Well,
you.
before you sit down,
Yes.
we do need to spend a little time talking about which, if any, abstention doctrine domain we're working with here. The district court made one judgment call about that, and we're here litigating that, that judgment. Assuming we have interpleader jurisdiction, the question is whether abstention is proper, and the district court used Wilton Brillhart abstention applicable to declaratory judgment actions. And the question was whether that was proper. That's a much broader abstention doctrine than any other conceivably applicable abstention doctrine here, the primary one being Colorado River abstention, so, which is narrower. If you would spend just a few minutes addressing that.
Yes, I'd be happy to. So Wilton Brillhart does not apply here. Wilton Brillhart is limited to the Declaratory Judgment Act, which has its distinctive, discretionary text.
And here we have an argument that the declaratory judgment counts in the complaint, or sort of the tail that's wagging the dog
Right.
here.
I understand the argument, but the case law is clear, including this court's case law in R.R. Street, that district courts have a virtually unflagging obligation to exercise jurisdiction over the non-declaratory claims in a complaint, so long as they are not wholly dependent. That's the phrase this court has used, wholly dependent on the declaratory ones. And I think amicus doesn't really even try to argue that the claims are wholly dependent here. They're independent. They have a distinct jurisdictional basis. They seek different relief. I'm talking about the interpleader claim now. And the outcome of the interpleader claim does not stand or fall with the declaratory ones. So
Well,
there's
how so? Because I think your whole argument is that your client wants the $10,000 back based upon the 5 claims that have nothing to do with the interpleader claim.
yeah. So with
that
respect,
seems
I
to
don't
me
think
that-
that's our entire argument, right? So there are ways that we can prevail on the interpleader claim without prevailing on the declaratory claims. I mentioned earlier the idea that
Standing.
nobody has standing, right? So that's a clear example. And the interpleader action gives us injunctive and equitable relief that the declaratory claim can't give us. So they stand on completely different footing from one another. And I think, the idea that the sort of comity can be appealed to in the abstract here, without tying it to one of the abstention doctrines through which those comity concerns are meant to be channeled, is just misguided. What we've got here is a federal interpleader claim and state proceedings that are or could be ongoing that concern the same subject matter. Okay, that's Colorado River, right? And as you said, Chief Judge Sykes, Colorado River applies only in narrow and exceptional circumstances. And there's been no attempt made here, I think understandably, to argue that those circumstances are present. So, I can talk to you about why Pullman and Burford and, the other abstention doctrines don't apply. They don't, right? So what we've got here is an attempt to use Wilton Brillhart to wag the tail of the dog. My metaphor got a little
It was a
tangled
poor
there, right?
analogy anyway.
No, my poor analogy, not yours, right? But we've got an attempt to say, well, there are declaratory claims in this complaint, right? And therefore the interpleader claim has to be abstained from. When in fact it's just the opposite. Because the interpleader claim is independent, right? It should be entertained. That's Congress's intent here. And oh, by the way, that means that the declaratory claims under R.R. Street are themselves also entertained because we want to avoid piecemeal litigation. So that's certainly our position on abstention.
Thank you.
Thank you, Your Honor.
Oh. Morning.
Good morning. May it please the court. I think it's important to more methodically go through the jurisdictional issues, but first I want to answer Judge Scudder's question. about status. And my understanding is essentially the same as Mr. Franklin articulated. The bottom line is there's only one pending case remaining, and that's Mr. Stilley's. Relatedly, I'm not so sure that Mr. Gomez could sue, because while SB 8 precludes application of non-mutual claim preclusion, it does not preclude application of mutual claim preclusion where there is identity of parties. Could Domino reinstitute his suit? I suppose he could, because it appears he took a non-suit without prejudice. And then finally, related to that, just to be clear, there is a statute of limitations. It's 4 years and it runs this September. So with that, let me address the.
Can I pause you real quick?
Yes.
Is there any legal significance to this? You guys largely agree with one another, status of it. Is there any legal significance to that in your view?
I think it further, well, in the realm of abstention, I think it further reduces the incentive for a federal court to get involved. This is not the multi plaintiff case that Dr. Braid feared at this point, and there's no indication that any suits are forthcoming. So I do think that it's something to consider. It's certainly not dispositive, but I think it's relevant to a court's discretion on whether to retain jurisdiction. As to jurisdiction, there are two fundamental problems here. First of all, there is not a specific identifiable fund. There is an inchoate contingent claim against Dr. Braid's general assets. And secondly, even if I'm wrong about that, the deposit here is insufficient. So let me talk about the fund. As I say, the underlying plaintiffs made a claim against Dr. Braid's general assets, not against an identifiable fund that is, in the words of the statute, in his custody or possession. That's not like an insurance policy that is in his custody or possession. And that's just not the kind of claim that can be litigated in interpleader. The only thing that gives this case the allure of a proper interpleader action is that SB 8 prescribes a minimum award. Dr. Braid deposited that minimum award, and there are multiple claims, or there were. But by depositing the minimum award, all Dr. Braid has done is to create an artificial fund. And we know it's artificial because there's no fixed definition for determining what the appropriate amount of the award is. Courts have discretion. If SB 8 prescribed a flat $10,000 award and no more, this might be a different case. But as it is, all we have, as I say, is a contingent inchoate claim against his general assets. If this is a proper use of the interpleader statute, then defendants subject to virtually any contingent or inchoate claim could manipulate jurisdiction by using the interpleader statute's generous venue and service of process provisions to oust state courts of jurisdiction and deposit a minimum that he thinks may be owed. Think of a court.
Can I ask you if you, and Mr. Franklin may want to respond to this too, if you think about classic interpleader, my understanding in preparing for today is that there is some flexibility in, not in SB 8, set this aside, this fact pattern aside entirely. In classic interpleader as to the deposit of the amount of the deposit in a fund. So for example, 1335 jurisdiction could be exercised in an insurance dispute where, say, policy limits are 800 or $1 million and 850,000 is put on deposit because all indicators to all parties at the time acting in good faith are that the dispute is, there's really no way there's more than $850,000 in, of injuries at stake. And when it turns out that there's $1 million, 1335 jurisdiction is not defeated that way. So there is, what's the point of the observation? There is some flexibility, isn't there in classic interpleader law as to the amount of the fund deposited?
I completely agree. If you have, for example, maybe this is your example, but let me just flesh it out a little bit more. If you have an insurance company with a policy and the policy holder sues the insurance company claiming that they've withheld the policy proceeds in bad faith, the insurance company can deposit the policy proceeds and create an interpleader action. And if there are consequential or punitive damages beyond that, that's a different matter. Totally agree with that. But we have to think about, okay, now we bring it back to this case. How do we determine what the appropriate amount to deposit is. And I agree with Dr. Braid on this. It depends on what the interpleader plaintiff, quote, asserts to be the subject matter of the controversy. Well, what does he assert to be the subject matter of the controversy? The 3 claims that have been made against him, which he attached to his interpleader claim. And as between Dr. Braid and those claimants, the largest amount in controversy is
What would
$100,000.
your conclusion be if right after the oral argument, there was a supplemental deposit of 90,000?
I think that could cure the jurisdictional problem, the deposit problem. I still think that there's an inchoate contingent claim here, because going back one step, think again about a contract or a tort case where liability is disputed. Could a defendant deposit in court the minimum that, just in case he doesn't win on liability, the minimum that he thinks the plaintiff is entitled to? I think that would, that's essentially what's going on here, and that would unduly broaden the scope of interpleader jurisdiction and encourage forum shopping, which this court has said is not the proper purpose of the statute. Now, returning back to the deposit requirement, why is the largest amount in controversy between Dr. Braid and the claimants, why is that the proper amount?
Because there's no realistic opportunity of recovery of more.
That's exactly,
The baseline
that's exactly right.
$10,000 fine.
That's
is
exactly right. That's
all
the
that's at
reasonable
stake here.
amount. But if you want a statutory hook, look at 1335A2, which says that the deposit is to, quote, abide the judgment of the court. That is to comply with or obey. And a court could enter a judgment for $100,000. And finally,
There's absolutely no basis for that in this context, because there's no injury. So even if the statute, the violation of the statute is sufficient injury under Texas law to provide standing to these 3 bounty hunters, only 2 of them remain in the case apparently, there's just no basis in anything in this record to assume as a matter of real practicality that anything more than the baseline $10,000 fine is going to be awarded in this case.
well,
They have no relationship to the abortion in question. They have no relationship to the state
The-
of Texas. They have no relationship to Texas public policy. They're just bounty hunters.
understood.
They're not going to get more than $10,000.
I understood as a practical matter, but as a subject matter, jurisdiction matter, you have to deposit the largest amount in controversy. And it has to be-
Realistically, in controversy.
Well,
To
look,
then Judge Alito on the Third Circuit.
I'll accept your point. That goes to the merits. I think that goes to the second phase, not the jurisdictional phase, but the second phase of an interpleader action. And so let's assume now that these jurisdictional requirements are met. What do we do with abstention? Well, Dr. Braid's core concern is that he can't get a fair shake in Texas. And I just don't think that that's correct. This court taught us in JB versus Woodward that state courts are co-equal to federal courts and are fully capable of respecting and protecting a plaintiff's constitutional rights. And there is no better evidence of that than number one, a Texas court, a trial court dismissed Gomez's suit for lack of standing, and a Texas Court of Appeals affirmed that dismissal. And secondly,
On different grounds, I think.
there's a footnote that might suggest that the court alternatively affirmed on standing, but it did affirm. And secondly, there's the Van Steen case, which is mentioned in the briefing. In that case, shortly after Dr. Braid filed this interpleader action, a Texas trial court ruled that the civil enforcement provisions at issue in this case were unconstitutional because they violate Texas's limits on standing and violate due process. Dr. Braid can get a fair shake in Texas. And the straightforward way to litigate his defenses is by asserting those defenses into a Texas court, which Section 209F specifically allows him to
What
do.
about the anti-preclusion provision in SB 8? I mean, he could win one of these constitutional arguments in a Texas state court and still be vulnerable to the same liability and $10,000 in damages or the $10,000 fine because that judgment has no preclusive effect on some other bounty hunter's action.
That is correct, and there are ways to potentially deal with that. Number one is the MDL statute, the Texas MDL statute, which I mentioned. Number two, there's nothing precluding a state court from entering a stay pending resolution of other claims. And third, this is something I neglected to mention in the briefing, but Texas has its own interpleader rule. It's Rule 43 of the Texas Rules of Civil Procedure, very similar to Rule 22, and it says, persons having claims against the plaintiff may be joined as defendants and required to interplead. So there are ways to deal with the problem that you've identified.
So SBA didn't close all doors?
I don't think it, I
It
think
closed many.
it closed many, and there's no doubt that it's strong medicine. But this goes to your point that this is a matter of substantial policy consequence to Texans. They wanted to deter violations of SB 8. They did it in an unusual way, but that is their prerogative so long as those provisions are not unconstitutional. Now, if
It's
I,
not indefinite exposure, right, given the anti-preclusion rule. So in other words, suppose, for example, just for discussion purposes, it went back to Texas and Dr. Braid resolved it for $10,000 with one of these people. Okay. Now, given the language of SB 8, it would be difficult to identify a good faith basis the moment that judgment is entered for another bounty hunter to bring a claim, correct?
correct.
You would wonder what is the good faith basis for it? There's no possibility of double recovery. Just read the statute.
There is no double recovery. That is a defense. Payment is a defense. And so,
What Dr. Braid understandably described, there could be a whole bunch of vexatious litigation, perhaps for a time, but the moment there's a judgment entered, 10,000 or more is paid, it's over.
it is over. And so the question becomes,
Unless I'm wrong
do,
about that.
well, do we, it's not even a question of trust. It's, do we allow the Texas courts to handle that situation? And do we trust them as co-equal courts to deal with those sorts of claims that may have been filed after a payment is made? And I submit to you that we should. That's what JB versus Woodward and many other cases teaches. Now, which goes directly to what is the standard for abstention here? My friend on the other side suggests that it's misguided to not pigeonhole this issue into one particular type of abstention. But again, JB versus Woodward says just the opposite. To insist on a perfect fit with an existing abstention doctrine is to potentially miss the federalism concerns that animate abstention doctrines generally. And while I think Wilton Brillhart applies here, ultimately it's sort of a sideshow because there are significant federalism concerns. First of all, this case intrudes on ongoing proceedings. Secondly, it presupposes that a Texas court is an inadequate forum. And finally, this case potentially requires a federal court to flesh out a statute that has yet to be fleshed out and is of a matter of substantial policy consequence to Texans.
Well, all interpleader does that by definition, doesn't it, in federal court? Because it takes the case from a state forum, moves it to a federal forum.
It can, but this court in the Lexington insurance case taught us to be conservative and wary of dealing with novel questions of state law. And this action thrusts upon the court the potential for having to resolve unresolved questions of state law. The last thing that I'll say is that deciding in Dr. Braid's favor would create both an inter-circuit split and an intra-circuit split. Coring taught us that this is an equitable remedy and that a court may exercise its discretion to decide whether to decide on comity and equity grounds and dismiss if there's an inadequate remedy, just like a preliminary injunction. Vulcan Materials did not change that. Vulcan Materials doesn't mention coring. It did not involve a claim for interpleader. It involved a legal claim for monetary damages. As a practical matter, I understand what Vulcan Materials says, are these wholly independent? I think Mr. Franklin is right about that. They're not wholly independent, but as a practical matter, they are very much interdependent. This is very much the tail wagging the dog. And if I just may finish the sentence. And even if I'm wrong about that, we're still left with an interpleader action, which Coring has said a court may dismiss, and a declaratory judgment action with this, which the Supreme Court in Wilton and Brillhart said a court can dismiss.
Can I ask one more question, Judge? Can I just confirm, there's been no injection, I want to ask Mr. Franklin this too, no injection of the doctrine of forum non-conveniens into the litigation at any point by any party?
Not that I'm aware of.
Thank you very much.
Thank you.
Mr. Franklin, you've used your time, but you can have an additional couple of minutes.
Okay, I'll take it. Thank you. Three quick points. First of all, the interpleader statute speaks of money or property, right? So I think amicus is incorrect in saying that the $10,000 was something other than money or property in his possession, right? So jurisdictionally, I think we're secure there. Second, amicus tries to paint a kind of parade of horribles where we allow interpleader here, then, you know, your standard issue tortfeasor facing many claims could try to use interpleader to do an end around state process. That's just not right. And it's important to understand why it's not right. Texas SB 8 is unique in that it makes every claimant adverse to every other claimant. Okay. That is, to my knowledge, unprecedented in the way it operates. So what the court would be doing here would not expand interpleader jurisdiction into areas where it's conventionally not thought to be appropriate, because in a typical tort scenario, you don't have that kind of adversity. Third point, and I think this is important, amicus says that you can get a fair shake in Texas if you're Dr. Braid. I think just even a cursory reading of SB 8 refutes that notion, right? Just the fact that there's a potentially unending parade of potential plaintiffs, total strangers, right, who can come out of the woodwork and seek recovery here, I think refutes that notion.
What about his point, though, Mr. Franklin, that Dr. Braid is fully capable in the Texas courts of challenging on federal constitutional grounds the various limitations or restrictions that are in the statute that, you know, he's understandably concerned about?
So he's not. I mean, Texas SB 8 purports to say, for example, to Dr. Braid, you can't raise a constitutional defense based on the idea that you had a constitutional right to engage in the conduct that you engaged in.
Sure, but that's accepting the statute by its terms. Why can't he argue, yeah, I've read it, I get it, I understand, I can't, my point is that that limitation, I'm kind of speaking, you know, is unconstitutional. You can't preclude me from challenging this on federal constitutional grounds. To so preclude me is itself a violation of the Due Process Clause.
I mean, I suppose potentially that argument could have some purchase with Texas judges, but that's not a reason to deny interpleader jurisdiction or to abstain from exercising it here, right? The interpleader court has business in front of it, and it ought to dispose of that business. You know, and I think it's clear that the federal court is a superior forum in which to litigate those kinds of constitutional defenses. Very briefly, he also mentions the idea of consolidating cases in Texas, but as we point out in our reply brief, first of all, you can't consolidate not yet filed claims the way you can in interpleader. And second, the anti-transfer provision of SB 8 basically says all parties have to agree before the consolidation can happen. So that is, I think, a pipe dream. At the end of the day, you know, what we're being told in essence here is the only way to avoid vexatious litigation is to pay up, right? Pay the ransom to somebody without standing, who's a complete stranger, who's seeking a bounty, right? That I think is not a disposition that this court ought to be comfortable with. And to answer your question briefly, I'm not aware of any invocation of forum nonconvenience in this case either. Thank you, Your Honors.
All right, thank you very much. Our thanks to all counsel and special thanks to you, Mr. Paul, for taking this appointment on a pro bono basis to act as a friend of the court to defend the district court's decision. Thank you very much. Thank you. And we'll move to our third case this morning, the United States against Bogareddy. Mr. Herman, whenever you're ready.
Good morning. May it please the court, counsel. My name is Josh Herman, and I am here presenting argument on behalf of appellant Venkatesh Bogareddy. We raised 3 issues in our appellate brief, and I'd like to focus on 2, sufficiency and the 404B issue. There's some interlocking, but I'm going to try to keep the arguments a bit separate, starting with the sufficiency argument. This case we submit is one of the rare cases that tests what this court announced in Garcia, which is what are the outer limits of the reasonable inferences that can be drawn given the relevant standard of proof. When even giving all reasonable inferences to the government here, the evidence was insufficient as to every count of the murder for hire convictions. Each of those convictions required Bogareddy to use a facility of interstate commerce or to cause another to travel with respect to count 4 in an interstate manner with the intent that a murder be committed. And when you look at all of the evidence, and especially we submit when you listen to the recordings, there is such a degree of inherent contradictions and uncertainty at every stage. So for instance, when the agent, the undercover agent.
Can I ask you a question?
Yes.
Isn't that uniquely the jury's responsibility to determine those conflicts? Because intent, right, is sort of the fundamental jury issue in a case like this. And why is it not up to the jury to determine whether or not your client had the requisite intent to commit the crimes?
Sure. So let me give you some examples on that, because we first of all, as a framing issue, the intent are the credibility arguments and the weighing of the credibility arguments being the province of the jury is not the type of argument that we're making here. It's when you look at the evidence, even on its face, when you look at Bogareddy's statements on their face, they create a contradiction, an inherent contradiction
That's the problem I've got.
So let me give you an example.
Because if there was no contradiction, the argument would be there's no evidence that he acted with criminal intent. And then you'd have a sufficiency of the evidence problem. But when there's a conflict, why is that not an issue for the jury?
So let me, it's a conflict between what Bogareddy said and what the agent interpreted him to say. That's what the conflict is. So for instance, when the agent at the June 6, 2019 meeting asked Bogareddy, and this is after the word gone is used, which the government and in the district court's Rule 29 order places an unbelievable amount of weight on the word gone. After the agent says, do you want him gone? And then there's some garbled communication that the agent then says, do you want him hurt or killed? And Bogareddy's answer is, I don't know.
Well, wait a minute. Bogareddy says, here, let me just read it. Bogareddy says, he can't. I'm talking like a coma like that. The agent says, yeah, I mean, the only problem with that is that's hard to do, right? And Bogareddy says, yeah, so the other way.
So Judge, but back before he even says that exchange happens, first of all, the word coma means that Bogareddy is coming into the situation not with an intent to kill, but with an intent to do something short of killing. But even before that, the agent asks him, do you want him hurt or killed? And Bogareddy says, I don't know. And even until the very end, the last meeting, Your Honor, October 2nd, 2019, Bogareddy is saying, I want to give him some chance. This is wrapped around comments throughout the meetings when the agent is pushing the idea of using a gun. First meeting, you want me to get a gun? Bagaretti, no. Last meeting, the first thing that Bagaretti says when he walks into the meeting, no gun, no shooting, some type of accident. A crash is okay.
Train looks good, train thing looks.
So on that, Your Honor, that is beyond an impossibility. And when you,
Wait, he says, Bagaretti, the agent says dead, question mark. Bagaretti says, yeah, even doesn't dead or in a crash, good enough. And the agent says, well, it's gonna be probably dead. And Bagaretti says, that will be okay.
but then he proposes, he agrees with the agent's idea of pushing this man
In front of a train.
in front of a train in New York when the man works at home from New Jersey. And when in that same conversation, when the agent brings up the train, Bagaretti's own words were not that he goes there. This is also the same meeting when there's an
But
agreement.
That's just a dispute about the method, not the,
But in,
the goal,
but
for lack of a better way to put it.
in the
Done.
in the context of everything, when he's supposed to bring also to this meeting half down for it to even proceed and he comes up short, it is all said and done one of the factors that moves this type of evidence into what we see in some cases of the equipoise, where there's a balancing of the evidence that does not tip it to beyond a reasonable doubt. So for instance, back to the question about like the I don't know. If I were to ask my son, do you want to go to Michigan or Illinois? And he says, I don't know. And then I were to tell his mom, exercising all of my biases, saying he wants to go to Michigan, right? And that would be an unfair and unreasonable and in fact irrational conclusion from what he said. Even if he said at some time during conversations or looking at schools, I like Michigan, I like Illinois, I like them both. Ultimately, what Bagaretti says at each and every meeting is, I don't know, you tell me what to do. There is a degree of uncertainty, especially when coupled with the ultimate plan on October 2nd. After 4 months of meeting is this train pushing incident where Bagaretti says at the same time, not that he goes there, right? And I take Your Honor's point that it's about a method, but contrast it to the methods that he rejected. The methods that he rejected include specifically using a gun. And you look at the other murder for hire cases that this court has considered, Mendel, Caguana, those cases all involve guns, a method of killing that leaves no doubt. And in this particular case, Bagaretti is all over the place. He's looking for the agent for guidance, which expresses that he's asking the agent, you tell me what to do.
So hold on. So is your argument, Mr. Herman, that the government has proved beyond a reasonable doubt that the defendant intended to badly hurt Mr. Ganisetti, but they did not prove beyond a reasonable doubt that he wanted to murder Mr. Ganisetti?
That was the defense at trial, Your Honor, that the
Yeah, but the point you're making here that these are subject, I think anybody in the room that read these transcripts would say these are two people that are talking either about really, really badly hurting somebody or killing somebody.
And Your Honor, the defense at trial again was that the discussions showed an intent to cause bodily injury, to harm, but not to kill, and ultimately to make that gap, that jump.
Right, so we know the jury convicted, right? And the conviction's being challenged on appeal. So the point I'm trying to make to discern from the argument you're advancing in the room here today is, are you saying there's one and only one way to view this evidence? And it is beyond the pale to view the evidence as involving discussion of a murder, but it is absolutely fair to view the evidence as a discussion about one person hiring another to badly hurt a third party.
That would be that latter point, that would be a reasonable inference to draw from the conversations. It would be an unreasonable inference in light of him saying, I don't know, of what he wants to do when it's a decision between hurt or killed. And when he specifically says, when asked what he wants to do, promotes the idea of a coma, mentions beating him beating him up in other situations, that he is expressing something short of murder. And that's where his intent lies. And in light of the inherent contradictions of what he wanted to do with respect to murder, we would submit that that would jump the rail for an unreasonable inference. I'd like to switch to the 404B issue unless there's points on the sufficiency, because this is where I think that the arguments with 404B interlock with the sufficiency arguments, because you can see from the government's arguments on appeal, Bagaretti's statements at the first meeting about researching how to use insulin to kill his wife in her sleep played a crucial role in the testimony at trial. And even though the government in its brief says it didn't talk about any kind of plans, in the closing argument, I believe it's at page 1325, the prosecutor specifically said that after talking about how Bagaretti had thought about and talked about killing his wife, says that he is obviously talking about these plans with his father. So the fact that Bagaretti is also talking about killing his wife, which is not charged, but it is a wrong. I don't think that there can be any debate about that him articulating something that he had quote unquote researched about how to kill his wife would qualify as a 404B wrong. And the government in our post-trial pleadings and in Judge Wood's ruling treats it as a 404B wrong, means that there was a particular type of analysis that had to be done, which completely was not done here. And in 2014, Chief Judge Sykes, you authored Gomez, and it's been since at least 2014 when there was a couple of companion cases where this court has provided district courts with a clear roadmap of how to do 404B arguments. And what the district court did, both pre-trial at App 7, page 7 and 8, and then in its Rule 29 order, I think at pages 21 and 22, is completely ignore that roadmap.
Isn't that harmless error, though?
No, it's not harmless error for two reasons. One, we would submit that the harmless error analysis should subtract the evidence of the testimony of the agent talking about Bagaretti's plans to kill his wife. That's the necessary component of this affecting substantial rights as you look at the evidence without the improperly introduced evidence. Secondly,
I'm not talking about the commission of the. I'm not talking about the verdict. I'm talking about, wasn't it harmless error as to the judge applying the pre-Gomez inextricably intertwined standard?
No, it wasn't, because if there's not clarification that you need to consider the non-propensity evidence or non-propensity reason for the 404B evidence, any district courts can simply say it goes to motive and intent without looking about whether or not that particular evidence is still in and of itself propensity. So in the government's brief,
Can't they be both?
they can't.
A lot of evidence that goes to motive and intent is propensity evidence, I would submit. Probably all of it.
Right, but for this, that's also where 403 needs to serve as a bulwark here. And there's absolutely no analysis of 403 here. So as an example, I think it might have been the Schmidt case from 2014 or another case. When you look at an example of the 404B, it's somebody who is has drugs in a house and a possession of a gun, and then you introduce the drugs in the house to show that he's having the gun in furtherance of protecting the drugs. Or in more recently, there was
Mr. Herman, wouldn't we do the 403 analysis? I mean, couldn't we do the 403 analysis? The alternative is what, to send this back for a new trial?
It is, Judge, because that evidence of the testimony regarding
But I'm trying to figure out the chain of reasoning here.
Yeah.
If we said, all right, under your articulation of the harmless error standard, we subtract the evidence from the calculus, okay, from what the jury considered, then we conduct our own harmless error analysis. Is that what you're suggesting, to determine whether there was enough evidence to convict?
My proposal would be to obviously reverse for a new trial because the jury needs to hear this case without it being polluted and infected with what was clearly propensity evidence. This was evidence that he intended to kill somebody else, another family member, and he's charged with a murder for hire of yet another family member. It is just a bullseye example of showing that he has a likelihood to kill other people and family members. In the trial centered around that in many ways, through closing argument, through opening argument, through the agent saying he wanted to kill his wife over and over again and he had plans. If there's no other questions on that point, I'll reserve the rest of my time. Thank you.
Thank you. Morgan.
Good morning, Your Honor, and may it please the court. My name is Alex Morgan, and I represent the United States. I'd like to start with the 404B issue. The district court here was well within its discretion in admitting the defendant's statements about wanting to kill his wife. The defendant's statements about wanting to kill his wife were evidence of defendant's intent, his
Ms. Moran,
motive.
can I ask you a question? Do you agree that the district judge applied the wrong pre-Gomez standard in determining the admissibility of the evidence?
I don't, Your Honor. I think if you read that opinion, I think what the district court is saying, and maybe it's less put a little inartfully, but I think what the district court was saying, what the district court was consistent in throughout its dealing with this issue, is that it didn't view this evidence as other acts. It viewed this as direct evidence of the charged crime, as motive and intent that go into the direct evidence of the charged crime. And so even in that ruling where that citation occurs, which I agree is no longer good post-Gomez, the principle from that case that direct evidence falls outside of the 404B analysis, that's still good post-Gomez. And I think that is what the district court was saying.
The reason she gave for that is inextricably intertwined. Gomez.
Understood. And I think that citation and the parenthetical may be erroneous.
Yeah,
but
it doesn't seem to me to be direct evidence either. I mean, I have a hard time of figuring out how it's direct evidence. I think the government's theory is defendant is divorcing his wife. Wife's uncle is paying the legal fees to support the wife's divorce. And if the uncle was vanished or hit by a train, I suppose, then there would be nobody to pay the fees for the wife for the divorce. So that has nothing to do with the death of the wife. You see what
understood.
I mean, it goes to motive. I mean, I'm with you on the motive and intent stuff.
Right. And I admit that it's a little bit of a close call on whether it's direct evidence or whether it's 404B evidence. And I don't think it ultimately matters because both motive and intent are permissible purposes under 404B. And the district court ultimately, though it thought that it was direct evidence, did the 404B analysis as well, discuss the evidence in terms of the motive and intent, did the 403 balancing analysis that is required under Gomez, and then additionally limited the way in which the government could use the evidence at trial. And so the way that the government is arguing this evidence, the way that the jury heard about this evidence is in terms of his motive and his intent. The defendant's intent was the key disputed issue here at trial. And the statements about his wife demonstrated his genuine intent to kill the uncle. The defendant's statements about killing his wife showed that he was serious about killing the wife's uncle, as opposed to just harming the wife's uncle, which is the theory of the case that defendant presented.
Ms. Morgan, the difficulty that I have with it is I don't understand why the government was so intent on proving that he wanted to kill his wife. The indictment charged him with wanting to kill the uncle. And it seems to me the government would have had plenty to say, Why does he want to kill the uncle? Because the uncle is encouraging a divorce. And the divorce is choppy and messy, as they always are, or often are. And that's why he wanted to kill the uncle. Why does the government have to get anywhere near this additional intent to want to kill the wife? That's not what the indictment is about.
I agree that the government didn't need that evidence necessarily, but I think that given that intent was a disputed issue here, the defendant's intent, his desire, not necessarily any plan to kill the wife, but his desire to do so tells us something about the divorce. It tells us something about his state of mind. And it tells us something about what he was willing to do in order to accomplish his ultimate goal. His ultimate goal was to permanently end his wife's ability to litigate the divorce proceedings and to cause him troubles with the custody of his children. So it wasn't that, the fact that that was his ultimate goal, I think, is really informed by his desire and what he's saying about killing his wife.
Both predisposition
Yes,
and lack of government inducement, or government inducement, I should say. So the government has to prove predisposition and a lack of government inducement once entrapment is put into evidence, as it was here. And so the sufficiency argument, the 404B, permissible purposes for the other acts evidence here, the desire to kill his wife, etc. That all has to be filtered through the nature of the case, which is it's an entrapment case. And the way this was initiated is that the defendant talked to an acquaintance about killing his wife. And so that's the context in which both the 404B evidence and the sufficiency of the evidence argument that are being raised on appeal needs to be evaluated, including any harmless error if the wrong legal standard was used by the district court in admitting the evidence about the wife.
understood, Your Honor. And I think that a rational jury could easily have found here that there was sufficient evidence to show.
Let's start with the 404B, because then that's
Understood.
the evidentiary
So,
argument that's being raised.
yes,
And there was
and-
there was no limiting instruction on the proper purposes
Of course,
of the argument of this evidence, which was a pretty glaring omission as well. Although there's no instructional error being advanced because apparently there was no request for limiting instruction.
that's correct. There wasn't a request for limiting instruction. And I will note on the entrapment part, this wasn't an argument that the government made below, but in terms of how the government argued predisposition at closing, the government pointed to the statements about the wife and said, look, he's predisposed to do this. If this were to go back, I think that would be an argument that could be advanced as well, is that not only does those statements come in for motive and intent, they also come in for predisposition. And as the jury was instructed, predisposition looks at a person's character, and kind of opens up this whole can of worms in that respect. So this evidence was certainly appropriate evidence of predisposition once the defendant put that entrapment defense at issue. And I think the evidence of predisposition goes beyond just the statements about the wife. The defendant came to that very first meeting knowing exactly what he wanted to do. He had this problem of his very bitter divorce, and he had thought about a solution. He wanted to get rid of the uncle. He came to the meeting with, prepared to discuss sort of the best way to get this done. And as defense counsel points out, there was some debate. They're talking about how is the best way to do this. But ultimately, he had his mind made up even at that very first meeting. And I'd like to point to the fact, too, that the defendant had already discussed this with his father, who was a police officer in India, to sort of discuss how to get away with this type of crime. And I think all that just goes to show that the defendant was ready and willing to commit the murder for hire offense. If your honors don't have any questions on entrapment, I'd like to just briefly touch on the sufficiency as to the intent. I think a lot of these issues are overlapping, and so we've kind of
touched on a lot of what goes into the defendant's intent, but I think as to every count, the evidence was more than sufficient to show that defendant had the requisite intent here that a murder for hire be committed. He came to that meeting knowing what he wanted done. He used words like taken care of, but confirmed ultimately through his conversations with the undercover agent what he was looking to get done, including agreeing to plan to push the victim in front of a train. And the defendant throughout these meetings continued to make that intent clear, including giving the undercover agent thousands of dollars, his wife uncle's picture and address and information so that he could carry out the crime. If there are no further questions, the government requests that this court affirm the defendant's convictions and sentence.
Thank you. Mr. Herman, I think you had used almost all your time, but you can have an extra couple of minutes to.
Thank you, Judge. So I'd like to address the point about the entrapment defense and predisposition. We acknowledge there's a fine line and sometimes even overlap between predisposition and propensity. How we addressed this in our reply brief was, at least in this circuit, in the McGill case, there's a tightened comparison between the charged offense and what you are making for an entrapment argument. So your character is just not some free-floating, every bad thing you've ever said could be relevant to whether or not you were predisposed to doing something else that was bad. So we'd rest on the arguments that really focus on McGill, and I think the government cited a case, an older case, looking at based on Ninth Circuit jury instructions, talking about similar enough offenses. Judge Scudder raised an important point about the that I want to draw a line under regarding the relevancy of the separate and apart from the entrapment issue about these comments at all. The district court's Rule 29 order opens up by talking about how Bhagirathi was indicted by a grand jury in connection with his efforts to hire a hitman to murder his wife's uncle in response to the uncle's support of his wife during the contentious divorce. The relevancy of his intent and motive was the fact of a pending divorce proceeding, not any underlying animus, and certainly not a plan and desire to kill his wife. So we would submit that even out of the gate, the 404B analysis stumbles. Absent any other questions, we appreciate the opportunity to present these arguments and would respectfully request that the convictions be vacated and it be resent to the district court. Thank you.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement. We're going to take another very brief recess to summon the attorneys in the next 3 cases and allow some additional students to come in. Okay, so our third case this morning is Dorad Sheba versus Christy Nome. Mr. O'Toole.
Good morning, Your Honors, opposing counsel. I represent the appellant in this case, Dorad Sheba, and my name is John O'Toole. Dorad Sheba, for the court's information, is a patriot of this country, a man who honorably served in the military and was discharged honorably. Only reason I mention that, Your Honors, is I believe, having served in such a capacity, he believes he brings to the table a lot of credibility that some other folks in our society do not have. Two primary issues in this case have to do with discrimination, the Rehabilitation Act of 1973, which is analyzed under the Americans with Disabilities Act, and a hostile work environment. One of the sub-issues in this case, as alleged by the defendant, is whether Mr. Sheba exhausted his administrative remedies. There is a 45 window involved, which he clearly violated. That being said, there are exceptions to that rule, and the exception to this rule that the appellant is stating is the continuing violation doctrine. I think for the purpose of the court, certain dates are important. Mr. Sheba was terminated on June 6, 2010. However, the Merit Selection Protection Board overturned that decision. Order was effective 2015, 2010, and he was ordered to be reinstated to his current position. He then served with the USCIS for approximately 2 months before he again went on disability. On September 27, 2011, he was referred to the Office of the Inspector General, or the OIG. The Office of the Inspector General issued its report on 3/15/2014, and Mr. Sheba was terminated officially August 25th, 2014. As cited in my brief, the Cleveland case decision by the U.S. Supreme Court, this involved a lady who was working at the company. She suffered a stroke. She went on disability and was fired thereafter. The court said that even though she may be in violation or negate one of the elements, as long as she has a sufficient explanation, that she would fall within the timing of the statute. I submit to the court that this is what happened here. Mr. Sheba, in his deposition testimony and as referenced in my brief, brought up the fact that had he been allowed and given reasonable accommodations, he would have been able to work. This is in connection.
Don't you have a qualified individual problem here? Because that's not what he said when he applied for disability benefits. He said he couldn't work.
That's right.
Even with the accommodations that his doctors were suggesting, he still couldn't work. And he had pressured his doctors to clear him for work. I think that's a problem.
He says in his deposition, Your Honor, if it's okay if I quote it.
Yeah, go ahead. There's no doubt in his deposition, he contradicts his statement,
That's correct.
but he doesn't explain it. I mean, a contradiction just, you can't make a sworn statement and then later deny it. And so we accept the deposition testimony.
Well, I think it's important because it brings up the reason why he wasn't able to work, and that was because he wasn't receiving accommodations. I understand what the Honor is saying, that he is apparently contradicting himself. But he said so because I really think it depends on how the question is asked. And so if I could just quote a couple stanzas here, Your Honor, I think it'll be clear. So the question poses, so which is it? Were you better and you could return to work, or were you never better? And answer, I was better during this time. And then because of the issues occurred, I got worse again, and I was worse again. Question, so your condition improved. You were able to return to work when I was accommodated. and you thought that as long as you had your accommodation, you'd be able to work. Correct. So I think what he's saying here is as long as he has accommodations, he can work, regardless of what the doctors say. If he's given accommodations which were identified by Dr. Curran previously, that he would be able to work, and those accommodations were pretty straightforward. One,
But I think in his statement, the problem is in his sworn statement, what he says is that he pressured the doctors into saying he could work with accommodations when he couldn't. So in other words, his statement, I know what the deposition testimony says, and you're exactly right, you quoted perfectly right. But in his statement, he says the opposite, and in the declaration, he just contradicts what he says in his statement. He never explains. He just says something different.
I don't think he was asked for further explanation. I think he would have provided it if he'd been asked.
The problem is he's saying one thing for workers' compensation benefits and something else to his employer about returning to work with
Yeah,
accommodations. That's the problem. He
Yeah.
said he was completely disabled for, and could not work for workers' compensation. But then saying he can work with accommodations when he wanted to come back, and that's the basis of his rehabilitation.
That's
Act
correct,
claim.
Judge. And that goes to the issue of judicial estoppel as raised by the trial
Right,
court judge.
that's the contradiction, is that he can't, he can't tell one agency that he can't work in order to collect government benefits and then tell his employer, a government agency, that he can work with accommodations and then turn around and sue when he's fired after 7 years on medical leave.
I think
I
maybe
mean, he was
that-
only back for 2 months,
That's true. When he suffered another injury and
so he was employed by
disabled.
this agency for 7 years without working more than 2 months.
Well, I think the operative
It's
time.
hard to argue that he was a qualified individual
Well,
who
other,
could be accommodated and perform the essential tasks of the job when he was
other than,
off on medical leave for 7 years and only worked for 2 months.
well, I think the operative time period is after the point he was reinstated by the Merit System Promotion Board. I think what happened prior to that is irrelevant. I think when there's no mention any place that other than his medical condition, he was not qualified for the position. There's no mention of it whatsoever. So assuming that's the only issue involved, I think the salient question for the court is, did the government fall down in not providing the reasonable accommodations he requested?
He's got, you alluded earlier, at the opening, Mr. O'Toole, to the timing problem your client has. He complained to the Equal Opportunity Office, if I'm right, in October of 2014 about events that were, or an alleged failure to accommodate back in 2010 or 2011. So he's outside of the 45-day window.
That's correct.
And you say, well, there's a continuing violation, but I don't know what you're relying upon there. Do you have to get into the whole business about the immigration matter that he raised with the United Nations?
I think that's
I
relevant
don't know how
because
that
that's
has
what's,
anything to do with a failure to provide him with hourly stretch breaks.
I think that's relevant because I think that's manifestation of the government's intent to get rid of him. The OIG investigation, which occurred starting in 2011, he was terminated in 2011 as well. He was terminated in January 2011. The government launched this OIG when he is out on medical leave in September of 2011. He had also testified in his deposition that during the time he was on medical leave, which was after December 22nd or from
But what is
January
it?
10th,
I don't-
2011.
Yeah, I don't see what is the connection in your client's mind between the investigation involving the UN and the failure to provide hourly stretch breaks to accommodate the injury he suffered when he fell in the bathroom? I don't understand. I don't see any connection at all.
I think the connection there is that it's an example that the government used in order to terminate him because they couldn't terminate him on medical reasons. If they wanted to terminate him on medical reasons, they could have done so on January 11th, 2011, when he was on medical leave. They didn't do so. And
Is that a
according,
pretext? Is that like translating that legally? Or are you arguing that what went on with the complaint to the UN and the misconduct on his part in connection with that it was pretextual by the employer?
I think it is, Your Honor. Yes, I think one could draw that conclusion. When you look at the results of the OIG, which they took over 2 years to complete, They had agents come to his house wearing armed pistols, intimidated his wife, they interrogated his family and friends.
You
I
argued
think there is
pretext
a
in your
pretext
brief. I
for
don't
that.
remember pretext arguments.
No,
Yeah, I
I
missed
think you can define that argument by inference, Your Honor.
Okay, you're out of time, Mr. O'Toole, so we'll hear from your opposing counsel, Ms. Flannery.
Thank you, Your Honor.
Thank you.
Counsel, may it please the court? Kate Flannery on behalf of the Department of Homeland Security. Your Honors, I want to address briefly a few points that opposing counsel raised. First, regarding the timeliness issue, appellant has repeatedly, throughout the course of this litigation, alleged that the OIG investigation was pretext or connected to his leave starting in 2011. The documentary evidence in the record shows clearly that the OIG investigation started as a complaint by the United Nations. The United Nations raised this complaint not to his employer, but to the State Department, who then raised the complaint to USCIS. And then individuals at the USCIS consulted with counsel and asked, what should we do about this employee who is out on leave, who is misusing his official position? Then counsel advised Ruth Dorochoff, an employee at USCIS, and said, you should report this to OIG. This is not disability discrimination. This is a report of misuse of his official position and being reported to the OIG. In addition, that's not part of a continuing violation. Mr. Shiba went on leave in January of 2011. He claims that his employers did not accommodate his disability on that date. That is a discrete act. Teague, this court in Teague said that the failure to accommodate is a discrete act. That triggered the 45 days to report this complaint to the Office of Equal Employment, and he didn't do that. He did nothing for 3.5 years, despite consulting with an attorney saying, I have a problem here. I disagree that they're not accommodating me. What should I do? And he did nothing. There's no continuing violation. He did not exhaust his claims, and the court should affirm that ruling. I also want to turn to the issue of judicial estoppel. Counsel seems to say that appellant didn't have the opportunity to explain this discrepancy. He had ample opportunity. He could have explained it in his deposition. He could have attached a declaration in support of his motion for summary judgment. He could have asked his doctors to submit documentation, but instead he stood on his statements. And those statements in front of the Department of Labor said, I'm unable to return to duty. I've never been better. I've always been sick. I pressured my physicians into releasing me back to work, and I was never ready to return. The court rightly concluded that he could not reconcile these contradictions, that he could now come back to work. This is judicial estoppel, and it's clear, and he was not able to explain those contradictions. Finally, I just want to briefly discuss the hostile work environment claim. Aside from the fact that some of those allegations were not exhausted, the court correctly concluded that as a whole, looking at the events completely, his termination by a letter was not severe, egregious. The OIG investigation was not severe and egregious, and taken as a whole, he did not raise a genuine issue of material fact. If there are no further questions, we ask that the court affirm the district court's ruling. Thank you.
Thank you. Mr. O'Toole, your time had expired, but I'll give you a little extra time in rebuttal. Go ahead. Anything further?
Yes, Judge, I'd like to address the issue of hostile work environment. As pointing out in my brief, I don't know what it takes. Does it take a bullet on somebody's desk to create a hostile work environment? Mr. Shiba very clearly points out the intimidation that he experienced. It's on page 18 of my brief, where he goes to point out how Melinda Leach, his first line supervisor, had destroyed his life, constantly looking over his shoulder. People entered his house with guns. His wife was terrified. And to give you some perspective, Your Honor, Mr. Sheba and his wife are of Assyrian descent, a religious minority in the Middle East who has been increasingly persecuted throughout the years. And all of a sudden, you got armed government officials appearing in your house. And then he's told that his previous acquaintances, Armando Lopez, his boss, has threatened to kill him. He quotes him and saying, "I will effing kill you, kill your wife and your kids, and bury you in the backyard." I don't know how much intimidation more is necessary. I think that's about as hostile as you can get. So I respectfully disagree with counsel. There is a factual basis there. There's at least a question of material fact that should throw out at least that portion of the summary judgment. So for any questions, Your Honor?
All right.
Okay.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement and move to our next case this morning, United States against Dukes. Mr. Van Zandt.
Morning, Your Honor, and may it please the court. I'd like to start the conversation today by picking up on a thread that Judge Scudder, you started in the first argument this morning, and I think Judge Kirsch picked up on too. This is another case in which we have a full jury trial. This case it's gone to trial, it's gone to verdict, and we're up now talking about sufficiency of the evidence. So what I'd like to explore a little bit is through the lens of that, the evidence in this case. Judge Scudder mentioned earlier on that this is often described as a nearly insurmountable burden. That's true. But the reason is because most arguments on insufficiency of the evidence focus on what rational jurors can and can't do. This is not a standard that we give straight to the jury and we apply minimal review on. What we have to talk about is what does rational in this case? Has the government provided rational reasons for the conviction? Has it told a story that holds together? And as part of that, the government cannot make speculative leaps. There can't be conjecture. This is a case that's all about circumstantial evidence. And what we have here is a case that's built on conjecture. It's built on speculation from beginning to end. So starting at the end.
I don't know, a strong argument could be made there's direct evidence given those Facebook posts.
Well, and that's a great question, Your Honor. So the Facebook posts themselves talk about Grand Theft Auto in general. What the government hasn't done is connected that up with the actual carjacking. Now, remember, we've got three separate incidents in this case. We have the carjacking itself. About 3 or 4 hours later, we've got the park shooting. And about 5 hours after that, we have the chase with the police and the crash. Now, the government points to these Facebook posts and says the only rational explanation for those posts is that Mr. Dukes was carjacking someone. That's not necessarily true, because when you look at the context of the posts, he talks specifically about running from the police. He talks about being chased. He talks about being in a car accident in the text back and forth
He
with his
also
girlfriend.
says, lost my phone, left pipes, IDC, which I think means I don't care. Long ass guy, I got away.
And that's absolutely right, Your Honor.
I mean,
He lost the pipes.
He lost his phone in the car that he carjacked.
Well,
He left the guns in the car that he carjacked. And he got away after the police chase.
Let me push back on that, Your Honor. So the phone was left in the car at the crash. That doesn't say that Mr. Dukes must have carjacked the car 12 hours earlier. It does tell us that Mr. Dukes was likely in the car at some point. That's conjecture to say that it must inevitably prove that he was the carjacker. Same thing with the lost pipes. Let's assume for the sake of argument that in the light most favorable to the government, that does mean guns. Where are those guns? We know that one was recovered from the car, did not have Mr. Dukes' DNA on it, did not have Mr. Dukes' fingerprints on it, and in fact was in the passenger seat where there was DNA for someone who was not Mr. Dukes. So I think it's a stretch and quite a conjecture and speculation to say that it must and can only mean that he must have carjacked someone when we've got this additional evidence of the accident and so on and so forth. So, but I take your point, and that's part of the problem here. It's easy to point to something the government has or an argument the government says, but we're not talking about the government's arguments. We're talking about what the facts are.
You you got to also account, and you're probably coming to it, Mr. Van Zant, for the fact that Angelica Rodriguez identified the defendant as one of the people that perpetrated the carjacking and was subject to cross-examination on the reliability of that identification at trial.
And that's an interesting point as well, Your Honor. If you recall from the transcript, Angelica actually did not identify Mr. Dukes at trial. She
Right,
never
no,
pointed.
I thought there's a pretrial photo array or photo book or something.
Correct. So that gets into the question about Dr. Wickstead's testimony. So the issue here is to set the timeline right. The incident occurs in July. The first time that Angelica gives a description is at the scene about 5 minutes later. This is actually on video and was introduced during trial, where she describes the carjacker as having a full beard. Now, we also know from the evidence, and it's undisputed, that Mr. Dukes didn't have a full beard that day. We've got those photos in the record. And that's something the government's never been able to push back on. So coming to the identification itself, we also know that she was shown, I think, 24 photos overall in Texas, March of the next year. So we're talking about, August of the next year. So we're talking about a month. And then the second identification was in March. So the point is, in the first identification in August, she identified 4 different people as, looks familiar. Mr. Dukes was one of those. She certainly didn't say, that's the guy. Now, the second identification, second photo pack, about 8 months later, the only person whose photograph was in that 6-pack was Mr. Dukes, despite the fact that she'd said 3 other people in the initial identification looked familiar, looked like the carjacker, might want to see them. So the question is, what do we do with that?
Well,
And-
all that was submitted to the jury, right?
Yes, of course, Your Honor.
Okay.
And I take your point that yes, the jury did see this, but we wouldn't have appeals if we just said the jury can see it and decide.
No, I know, but the question is, does it go to weight or admissibility?
That I think is a separate question, Your Honor. I think it goes to weight, and that's because of the way this was set up. But the point of the fact is, we've also got indisputed testimony from Dr. Wickstead about how memory works.
Yeah, but even if the eyewitness identification here wasn't perfect, which I think is the point that you're making, and the jury could conclude she identified the wrong man, you then got the Facebook messages with his, I suppose his child's mother, when he writes, "Bitch, I was in an effing," you didn't use the word effing, I'll just say that. I was in an effing accident and almost got locked up for 2 pipes. I lost my phone. I was in a high speed.
You're absolutely right, Your Honor.
So
And my point as to
that
that,
doesn't mean that he committed the carjacking.
that's exactly it. And that's the problem here is the government easily makes that leap. That's fine.
But the
That's,
jury did too.
but that's argument, Your Honor. And my point is there has to be a connection. They've got to connect it up. The jury can certainly make reasonable inferences from the evidence. What it can't do is speculate. What we have based on the Facebook posts, and you're absolutely correct, we have a high speed, we have lost pipes, we have a lost phone. None of that has anything to do with the carjacking 12 hours earlier. So while I would agree that that's sufficient for finding that he possessed or he was part of the gun, in the car at the time of the accident, left his phone, et cetera, that doesn't move the ball on the carjacking. And that's the problem here with sufficiency of the evidence. We cannot conjecture, we cannot speculate. That's what this court has said.
What about his posting of a Facebook photo of himself with connecting the shooting to the funeral of a friend?
I'm glad you brought that up too, Your Honor.
Gray hoodie with the purple ribbon from the funeral in the car.
So for context, what we're talking about is there was a funeral for Mr. Dukes' friend that day about, I think it was noon. Everyone wore purple ribbons to commemorate him. The government's theory is that Mr. Dukes stole a car sometime that afternoon so that he could commit a shooting in memory of his friend and then posted, "We did it for you." That's the theory. Now, the problem with that is it's all speculation. All we know is there was a sweatshirt found with a gray sweatshirt found with a purple ribbon on it in the car. That tells us that, let's assume it was Mr. Dukes, just for the sake of argument. It's in the light most favorable to the government. That tells us that Mr. Dukes was in the car at some point. The interesting part, None of the carjackers were described as wearing a gray t-shirt or a gray sweatshirt with a purple ribbon on it. The only inference then is that had to enter the car at some point after the carjacking. So even in the light most favorable to the government, all that tells us is that Mr. Dukes was in the car and left his sweatshirt at some point after the
Well,
carjacking.
there are reasonable inferences to be drawn from that evidence that he was involved in the carjacking. I mean, what you're making is essentially a jury argument, and the jury rejected it.
Well, no, Your Honor. What I'm pointing out is that the government actually does not have any evidence to connect the two, because we can certainly say it connects it to the carjacking. The only fact is that the sweatshirt was found in a
It's an
car that
it's
was
a
stolen.
Very serious coincidence.
Not necessarily, Your
I
Honor. I mean, I think
This is a classic jury argument that it's too coincidental that all these things would converge and not point to your client.
not necessarily, Your Honor. And I think we can craft a timeline that actually makes a lot of sense. Carjacking occurs, park shooting occurs, someone drops off the car, Mr. Dukes ends up in it at some point and happens to be the last person playing musical chairs.
Right, but the government's theory and timeline is quite reasonable under the circumstances.
But is it supported by the evidence, Your Honor? That's the issue.
Well, what the jury was told, you're not given the full picture of what the jury was told. The jury has, a Ruger firearm is found in the car.
Mhm.
There were shots fired in the park from
Mhm.
that Ruger firearm, right? And Mr. Dukes, your client, is saying, I lost 2 pipes, almost went to jail, etc. And the whole government's theory was that your client committed the carjacking in order to commit the shooting for D. Nice, his
Mhm.
friend, right? That's the whole, it's the government's theory. That's how they connect the dots. And sure, there is an inference that the jury has to make that he committed the carjacking to do the shooting. But the evidence sort of on the back end is so strong, I think that it supports the eyewitness identification on the front end, if that makes sense.
Let me push back on 2 points on that, Your Honor. So first of all, you mentioned the Ruger. The problem with that, connecting that up to the carjacking, let's say at most it connects him to the park shooting. There was no testimony that there was a Ruger at the crime scene. Angelica was very clear
Oh, right.
that was a Glock.
No question.
So if we're talking about Mr. Dukes had a Ruger, Mr. Dukes had a Ruger, that necessarily precludes him from being the person that had the Glock, if we take that for what it's worth.
I
Now-
don't think they were the victims of the carjacking weren't talking about the brand of the gun. They were saying somebody pointed a black gun at me, and a black gun was found in the car.
No, Your Honor, we actually got into that in a lot of detail on Angelica's testimony, and we specified that it was a Glock versus a Ruger. The reason it was important is one has an internal hammer and the other does not, which makes them very easy to identify. Angelica did talk about that.
Did the Angelica's mom or aunt or somebody, wasn't she one of the victims?
Yes, Your Honor, Sarah. She
Okay.
did not have any identification at all. Neither did Isabella, who was the other person in the car.
And I thought, didn't one of them make a statement to the police there was a black gun pointed at us?
Yes, that came out, but in terms of the identification of the person, they didn't have anything related to that.
Okay, but one of them said black gun, and lo and behold, a black gun's in the car.
I mean, how many black guns are there out there, Your Honor? I mean, that's
No, but
That's
Judge-
quite a reach.
What Judge Kirsch is saying is when you combine it all together, a jury operating under the standard of review that we're reviewing this could say, I mean, you start to rule out coincidences at some point in time here.
Well, and that's the issue, Your Honor. Let me actually get back to one of Judge Kirsch's points before I go on. Talking about the park shooting and that it was in revenge or in memory of his friend Daryl. Daryl died of epilepsy. He wasn't shot. He didn't get killed by rival gang members. So for that to be true, the only possible way you could get there is by saying Mr. Dukes is the kind of person who shoots up parks when his friends die, regardless of the reason. That's not logical. That's not
Hold on,
rational.
It was the defendant, not anybody else. It was the defendant who said, D. Nice, it's your day. We did it for you.
Yeah, his funeral, Your Honor.
Did
So
what, put the funeral on? for him?
absolutely. And that's the problem is that the government has not, they take this argument as far as they can. And I will agree. That's a fine argument to make. The question is evidence. What is the evidence that what he's talking about? And why would he be saying something like that when his friend died of epilepsy? There's no evidence to support that, only a conclusory argument based on character. That's the problem here, Your Honor. And I completely agree that when you look at the arguments, it makes sense. But when you look at the evidence the jury had in front of it, you can't rationally connect each point to the other. And that's the standard of review. I'm way over my time. Unless there's any other questions right now, I'll yield to the government.
Thank you. Is it Vizovic?
Ms. Vizovich, may it please the court, Jasmina Vizovich on behalf of the United States. Your Honors, ample evidence supported the jury's guilty verdicts here. Along with the DNA and along with defendant's DNA and his cell phone found in the carjacked Equinox next to one of the victim's cell phones and next to a black firearm, there was other evidence that connected the defendant to the carjacking. Defense counsel or opposing counsel relies solely on Angelica's second lineup identification, but that's not the only evidence from the victims that supported that the defendant was the carjacker. There was defendant matched to the description of one of the carjackers, both in appearance, and we know that from Isabel's testimony, one of the other victims, and from Angelica's testimony. And that appearance was 6 foot tall, thin but fit black man, and that is consistent with what his driver's license showed and what the jury saw at the defendant's table. He also matched the appearance of one of the carjackers in clothing. So Isabel said that one of the carjackers was wearing a red shirt and saggy blue jeans, and Angelica said that one of the carjackers was wearing a blue shirt with some sort of design on it and red-orange skinny pants, essentially. And clearly, the reasonable inference there is that Angelica flipped those colors. And defendant posted a picture of himself when he talked about doing it for D-Nice, wearing a red shirt and saggy blue jeans on the night of the carjacking. And then, as your honors have mentioned, not only did we have that he was consistent in appearance, that his DNA was in the car, that his cell phone was in the car next to Angelica's cell phone, we also have his statements, which were an important piece of the case here because they're defendant's own words. And in particular, the day after the carjacking, the defendant bragged about doing it. He said, "I was playing Grand Theft Auto." That is a reasonable inference for the jury to make that the defendant, amongst all the other evidence, admitted to committing the carjacking. So it's simply not true that the only identification here was Angelica's second lineup identification. There was more than sufficient evidence to find that the defendant was guilty of the carjacking. And as your honors mentioned, everything that defendant argues in his briefs about the unreliability of Angelica's lineup identification or whether that second lineup identification should have been done differently was all presented to the jury through not only the closing and argument, but also through the defense expert, extensive cross of Angelica and other witnesses. And that yet, despite all of that, the jury returned a guilty verdict. One point on the Glock versus Ruger point, the victims in this case were a 17-year-old teenager, Isabel, and a 20-year-old Angelica. Neither had extensive gun training at that point. They both stated that there were black guns that looked like Glocks. A reasonable inference is that a Glock is a pistol. You know, that's a common phrase or a common brand of gun. We also had in the case significant case agent testimony that explained how Rugers and Glocks are very similar looking. And the only difference was the existence of a hammer, which would not have been visible to a victim who was staring at two black guns pointed at their face. So the existence of the Ruger pistol in the Equinox the day after the carjacking is further evidence that that the defendant was the carjacker. And in terms of the 404B, the district court was well within its discretion in admitting evidence about the Park shooting. The Park shooting was probative to prove defendant's motive and identity as the carjacker and to prove that he used a loaded and operational gun at the carjacking, which helped prove one of the elements of the carjacking offense. And specifically, the government had to show that the defendant intended to cause death or serious bodily harm when he took the Equinox. And one of the ways that the government did that was to show that the gun was loaded and operational just a few hours after the carjacking when it was used at the Park shooting. The Park shooting was also direct evidence of defendant's possession of the Ruger pistol found in the crashed Equinox. And the probative nature of the Park shooting was not substantially outweighed by the risk of unfair prejudice. Here, as your honors know, The evidence regarding the park shooting was significantly sanitized. There was no mention of anyone being shot. There was no mention of this being a gang shooting. The jury did not hear any of that. Instead, they heard very limited evidence that a few hours after the carjacking, there was a park shooting, in which the Ruger was used to shoot 14 shots, and witnesses saw an Equinox leaving the scene. And at closing, the government significantly limited the references to the park shooting to motive and identity of defendant as one of the carjackers, and proving that the gun was loaded and operational as one of the elements of the carjacking itself. And again, going further down the 404B analysis to the 403 analysis, the limited evidence of the carjacking was not unduly prejudicial when compared to the evidence the jury heard of the violent and traumatic nature of the carjacking itself. So as your honors are aware, the jury heard evidence that a 40-something-year-old mom and her two teenage daughters, a 17 and a 20-year-old, and their 7-month-old baby were carjacked in the middle of the day when they were dropping off food at a barbecue. The jury heard how two men with two guns pointed at the victims' heads tried to steal the Equinox, and that the victims frantically tried to get that baby out of the car. And the jury heard all of that. They saw all three women on the stand. They saw the women get emotional as they recounted these events and talked about the trauma they incurred that day and the trauma that they still incurred up till the day of the trial because of how traumatic and violent this incident was. And then finally, the judge in this case gave two limiting instructions, as is instructed by Gomez, to further reduce the prejudicial nature of this evidence. One, before any evidence of the shooting came in, the court told the jury that the defendant had not been charged in the shooting and that they may only consider the evidence to determine whether defendant participated in the carjacking and whether he possessed the gun. And at closing, the judge again instructed the jury to only consider that evidence for those specific reasons. Given all of these facts, the district court did not abuse its discretion in allowing the jury to hear the limited evidence presented regarding the carjacking. And if there are no further questions, the government asks that this court affirm the district court's judgment.
Thank you. Mr. Van Zandt, your time had expired. If you have a brief rebuttal, I'll give you a little bit of extra time.
Just 2 points to wrap up, Your Honor. And I think that what I want to point out is that the government said the jury heard it. They heard all these arguments. That's true. But that's not the end of it. And if the standard review means anything, we don't stop there. The problem is with the government's position, anytime there's evidence that doesn't fit the government's theory, well, the witness just made a mistake. Angelica testified it was a Glock, but it was really a Ruger. She just made a mistake. No evidence for that. Angelica must have flipped the colors of the flipped the red and blue shirt. She must have just done that because Mr. Dukes happened to be wearing a red shirt that day. But that doesn't fit the government's theory. So she must have just made a mistake. That's not the government's burden. The government's burden is to connect up every single piece of evidence so that we can rationally make a conclusion to the next one. That's what I'm talking about today, and that's what I asked the court to consider as it reviews this case.
Thank you. Our thanks to all counsel. We'll take the case under advisement. And our last case this morning is Cave versus Valenti. Ron.
May it please the court, counsel. My name is Steve Ron, and with co-counsel Michael Hampelman, we have the privilege of representing officers Colin Valenti and Demario Johnson of the Springfield Police Department in this matter. On October 7 of 2019, at around 10:30 p.m., the officers were called to the home of plaintiff Julia Cave and plaintiff Larry Anthony Greer, also former plaintiff Larry Greer Jr.
Mr. Khan, can I ask you some questions here just to understand what is going on in this case?
Yes.
Okay. Do you agree Did the excessive force claim brought by Julia Cave or the excessive force theory should be submitted to a jury? The tightening of the handcuffs.
No, I don't believe there's any evidence at this point, or that the officer had any knowledge that there was any tightening of the handcuffs.
Well, she said it.
Correct.
So isn't
But
that
she
the end of
said,
it?
but every defendant says, I said not to, or to take them off, not to tighten them. The question she was asking was for them to take it off. And based on her, just the officer's knowledge that she had lupus, I don't think there's any case law that suggests that a reasonable officer knows what the effect of lupus would be in those situations. That if somebody claims to have lupus, they are not able to be handcuffed.
So what's the defense, what's the officer's defense at summary judgment with respect to that particular theory?
The officer's defense is that she was unruly, she was out of control, she was interfering with their investigation.
I got it, but how is the judge to determine that at summary judgment? How is the district judge, those are disputed. She's not admitting to any of that stuff.
I think what the judge is basically saying and what the plaintiff is basically saying is that if a person claims to have lupus, the officer needs to know not to handcuff them.
Well, no, I don't think it's that. I don't think it's quite that. I think what she's saying is she told the officer she had lupus, the handcuffs were hurting her, and she asked them to loosen them, and the officer instead tightened the handcuffs. Now, I know the officer totally disagrees with that characterization, and she very well may lose at trial, and there are ways to deal with vexatious litigation and frivolous claims and things like that, but that doesn't necessarily mean that a plaintiff doesn't get a trial on that claim. And I mean, I don't understand that your theory to be that the officers had qualified immunity for this. It just seems to me to be that this is just a disputed fact as to whether or not the officers engaged in excessive force in putting handcuffs on her, briefly detaining her.
I believe we are relying solely on that particular point on qualified immunity, that a person saying that they have lupus is sufficient to suggest that they should not be handcuffed.
Right, let me go on to the next one. What about the excessive force theory submitted by Larry Anthony?
I think there was no excessive force, and there's not a factual dispute on that point because it's all supported by the videos. In this case, we had a person, the officers arrived at what can be called a melee. There was a bunch of people yelling. Two of them at least were either in the process of fighting, about to fight, just finished fighting, or whatever, and they tried to, they didn't know who called the police, who was the victim, who's the trespasser, who's the homeowner, and all they see is a bunch of people yelling at each other, about to fight, and a person runs into the house. Now,
Mr. Ron, can I ask you a question? One of the things that I have had a heck of a time with, and I'm going to ask your adversary, I've had a heck of a time in this case figuring out what is it that is before us on appeal? What is it that you want us to decide? There are, and I'll tell you exactly why I'm saying this. The complaint that was filed in federal court is massively confusing. It has a single Fourth Amendment count with multiple bullet points under it as to theories of liability. When the litigation proceeds in the district court, there are very confused efforts to put qualified immunity on the table. This case comes to us on appeal. I know the names of the people that are involved. I can tell you that much. I can tell you who the police officers are, and I can tell you who the plaintiffs are. What I can't tell you with any confidence is what you want us to decide on appeal. I don't know.
I would like the court to find that these officers had qualified immunity for detaining these two individuals for a short period of time.
Which two people as to what alleged conduct?
Larry Anthony and his mother, Julia Cave, were the two people who were Julia Cave was interfering with our ability to figure out what was going on. Larry Anthony ran from the scene into the house.
I know, I think I have a sense of what happened factually. So you want us to decide as to the two police officers, a fourth on the merits or on qualified immunity?
On qualified immunity.
As to Julia Cave, as to what? The handcuffing alone or the detention that preceded the handcuffing?
There was no detention that preceded the handcuffing.
I thought she was eventually handcuffed and then the handcuffs were tightened, right? Is there a seizure claim that it's just a seizure of her?
Yes.
Okay, that's
she
Ms.
was
Cave.
handcuffed and then
And you want us to
placed
decide
in
that
the,
on qualified immunity grounds?
yes.
Okay,
And then
go ahead.
And then on Larry Anthony's, I would like you to decide that when a person runs from a
Hold on.
melee,
What defendants and what alleged
Larry
claim?
Anthony,
What claim? Larry
that-
Anthony,
that
Larry
he was
Anthony is a plaintiff. The defendants are the police officers.
correct. And that when an individual runs from a fight scene into the house where the officers don't know who was involved, they just arrived, they're entitled to bring that individual back out so they can sort out everything. And when that individual answers the door with a bat, the officers have qualified immunity to disarm that individual.
Okay, is there any issue before us at all as to the police officer's entry into the home?
Yes, the plaintiffs have made that argument. I think that if a person that is justified under qualified immunity as well, when a person enters the door with a baseball bat and refuses to drop it, the officers are entitled to disarm them. Necessarily, that would
What, exigent circumstances or what?
yes, that he poses a threat to himself and the officers.
And have you ever raised that? Is that briefed anywhere? Because I don't see any issue in the briefs that you've submitted. There's no reply brief. In the briefs that are submitted, I don't see any challenge to the district court's handling of the police officer defendant's entry into the home, warrantless entry into the home. So when I don't see a challenge to that, I think maybe the defendant officers are agreeing that that claim, which is in the complaint, should go to trial.
No, that's not the case, Your Honor. We argue in our brief that when the Larry Anthony answers the door with a bat and they don't know his role in the whole situation here, whether he was a perpetrator, whether he was a victim, they are entitled under qualified immunity to disarm that person. And if need be,
Are you confident that in 30 seconds here, that your adversary is going to agree with your characterization that Larry Anthony Jr. opened up the door and displayed a baseball bat?
Yes, that's on the body-worn camera video. The dispute is whether he ran into the house with the bat.
So it sounds to me like you want us to decide the issue with Miss Cave, the handcuffing, Larry Anthony Jr., the entry into the home, or Larry Anthony, what's his name, Greer?
Greer.
Okay, the entry into the home. And once inside the home, the detention of him. Are there any other issues?
Those are the three issues, yes.
And what two defendants?
Colin Valenti and Demeraro Johnson.
On all three of those claims?
No, only Colin Valenti is the count against, or Julia Cave's count is only against Colin.
We have to decide this, defendant by defendant, claim by claim.
Yes. Julia Cave has a claim against Colin Valenti only. Larry Anthony has a claim against Colin Valente and Demeraro Johnson.
Okay, thank you.
Mr. Brown?
Hi, good afternoon, everyone. May it please the court, my name is Dylan Brown, and I represent the Appalese, Julia Cave, and her son, Larry Anthony
Mr.
Greer.
Brown, can you start right where Mr. Khan left off?
Uh,
Because those are the same questions I'm asking. I mean, what are you asking of us?
What do we have to
What is gonna
decide?
go to a jury?
Sure, so the issues that immediately have to go to the jury are the unreasonable force against the two remaining plaintiffs, because those weren't addressed at all on appeal. Only qualified immunity as it applies to the seizure and detention. And I would argue that they barely even addressed the warrantless entry into the home.
Wait, so in unreasonable force, you're talking about with respect to Julia Cave, you're talking about the handcuffs, right? The
yeah.
tightening of the handcuffs, not the putting in the handcuffs. That was resolved at summary judgment. And under the circumstances, there's no issue there that what the officers did was reasonable when they put her in handcuffs.
Well, we think that the detention itself was unreasonable, but until the actual putting on the handcuffs too tight, then with the knowledge that she had a medical condition, and the judge found this, that no reasonable officer with knowledge of this medical condition and the pain that
Right,
was
so that's the
caused.
theory, excessive force.
Yeah, that's,
Right.
yeah, that is with the handcuffs. And then there's also an excessive
So
force.
there, I mean, I'm getting more confused. Is there a challenge before us to the original detention of Julia Cave? Not the tightening, forget the tightening of the handcuffs. I understand that.
Yes, so the defendant officers, the appellants, argue that they're entitled to qualified immunity because detaining Julia Cave was objectively reasonable under the circumstances.
So in your view, that's before us?
In my view, that is before.
The
yeah.
original detention and then second, the tightening of the handcuffs.
Well, we believe that that is actually not in front of you because that's the unreasonable force, which they didn't even brief or raise in their
See, one of the things that I
appeal.
think has made this immensely difficult
Sure.
is the way that you prepared your complaint. And it's you, it's not, the court doesn't prepare complaints.
Understood.
If there are multiple instances of Fourth Amendment violations or allegations of Fourth Amendment violations, we often see them set out as separate counts.
Sure.
Violation 1 is count 1, violation 2 is count 2. And what we have here are a series of bullet points.
Right.
And it's been very difficult to sort out what happened with each of those bullet point allegations and what is now on appeal.
Okay. So we would maintain that what the live issues are the warrantless entry into the house, which is an unconstitutional seizure, and also the lawful seizure and detention of both Julia Cave and her son, Larry Anthony. And then we also believe that the unreasonable force or excessive force claims are not actually in front of you, but are live claims at the district court because they were not raised on appeal. That's our opinion. And we raised that early in our response brief to say, well, let's also talk about what isn't in front of you and what is not subject to this appeal. I believe that we raised that pretty early on.
Do you litigate the entry into the house separately from the other aspects of what was going on with Larry Anthony Greer?
Well, we addressed it at the appellate, or I'm sorry, we addressed it in the summary judgment level where we talked about warrantless entry is in itself an unconstitutional search and seizure.
And was that a separate claim?
Yes, ma'am, it
from
was.
The claim involving the
Yes, it was.
search of the house?
Yeah, it ties into the search of the house.
Well-
It's separate than the illegal detention of the individuals themselves. So it kind of goes the
Well, I
warrantless.
know it can be.
Oh,
I'm
sure.
questioning whether it was in this litigation.
I
It's
believe
part of-
so.
It's part of this problem about isolating what claims were actually raised in this case.
Right.
And what defenses were raised. And that's what the court is struggling with on both sides because the presentation was really confusing.
I apologize for that. So, like I said, we believe that on appeal, at least, qualified immunity.
Let's start with
Okay.
what was presented
Sure.
as a claim. If you can just in one quick minute, tick through the claims that you presented to the district.
Sure. we'll separate the dismissed claims, obviously.
Right.
But the ones that we presented to the district court were unreasonable and excessive force against, from Julia Cave, unreasonable excessive force claim for her son, Larry Anthony, unlawful detention of both Larry Anthony and Julia Cave, and then also the illegal warrantless entry and search of the house.
Well, you lost on summary judgment regarding any of the claims having to do with Larry Anthony.
No,
Right?
only his father, which is also in of itself confusing because the father is Larry Greer Jr. So his case was dismissed on summary judgment.
But the issue of the search that turned the search of the house and
Yeah.
the arrest of Larry Anthony had to do with the dispute over the bat, right?
Well, I
Whether
think,
he had a bat outside the house or only inside the house?
well, I think that they have, and this is getting kind of argumentative, but we believe that they created a false narrative that he possessed the bat outside of the house, which then necessitated this pursuit into the house, which, and then this violent tackling. They put a taser in his back, they threatened him and tackle him. And it's this total, in the words of my opposing counsel, this melee inside the house under these false pretenses. And we think that the warrantless entry into the house in of itself is its own claim, which is a claim that both Larry Anthony and Julia Greer have. They are the homeowners, but then also the detention and violent seizure of him would be a separate claim of Larry Anthony.
Yeah, now this sounds different. What you're saying in the courtroom is clarifying, but I will tell you, it seems different to me than what you filed in the complaint and the way it was litigated. It seemed to me that the argument was being made that the reason there was a problem with a warrantless entry into the home was because once inside the home, they unlawfully seized Larry Anthony Greer. And I'm thinking to myself, hold on, there could be two Fourth Amendment violations.
Right.
The first is the unlawful entry into the home, and the second is what then transpired inside the home.
And if I haven't made my point, that's the point I'm attempting to make. So if I'm not doing it well, I apologize. But that is how we view the entry into the home as two separate Fourth Amendment claims, when one of them then becomes the violent detention and seizure of the individual himself.
Right.
So I thought that we had addressed that well enough in section C of our brief, and if we did not, I apologize. But anyway, briefly, I will say, though, respectfully, I'd like to reiterate our position, though, that we don't believe that this court has jurisdiction for this appeal on the issue of qualified immunity, because we believe that Judge Lawless found that the defense here turns on disputed issues of fact rather than law, and this court's precedents on this issue are well established.
Well, that's why I was trying to get to the bottom of what claims were litigated and how were they decided by the district court with respect to Larry Anthony. The younger, it has to do with this dispute over whether he had a bat outside the house or just inside the house.
Sure, and Judge Lawless identified this very factual dispute, and she held that, quote, if he did not have a bat, then the officer's warrantless entry into the home and subsequent detention of the minor would not be objectively reasonable. So we believe that she clearly found that to be a fact-based issue about whether they're entitled to go in the house in the first place, whether there was any objectively reasonable reason to pursue an unarmed minor into his own home.
Part of it is a factual dispute. The other part is a legal conclusion, and we do have authority to review the legal conclusion. And it really doesn't matter whether he had a bat outside. It was a very volatile, violent situation, and he fled through the yard without stopping when he was told to stop. And so whether or not he had a bat outside really doesn't matter. There was probable cause to pursue him based on the nature of the police call, which was responding to a domestic incident where someone was being held inside the house against her will. And as the police are responding to the scene, Larry Anthony, the younger, arrives and starts running across the yard and enters the house without stopping, even though he's being ordered to stop. And one of the officers thought he saw a bat, the other officer didn't. but they're entitled to pursue at that point. So it doesn't really matter whether the district judge thought that the dispute about the bat made a difference. What matters is what this court, how this court views the record and whether the legal issue turns on the existence of the bat or doesn't turn on the existence of the bat outside the house. We know he had one inside the house.
Okay. Yeah, I guess I would just slightly push back on the notion that either of these cops saw him fleeing into the house. His first appearance as on Officer Kapranica, the first responding officer from the Springfield Police Department, he's seen on Officer Kapranica's, and as Judge Lawless notes, he's clearly not holding a bat. And then by the time that Officers Valenti and Demario Johnson arrived to the scene, he's already on his porch. So the notion that they're saying, "Hey, stop, stop, stop," I mean, he's already on his porch.
One of
So
the officers said he had a bat outside the house. That's the dispute that the judge was focused on.
that's true, but she also noticed, well, and it's our position, of course, that this is all a fabricated effort because these officers knew that their actions were objectively unreasonable, and then they paper over the record, which includes filing false police reports, claiming that they were responding to a call of an individual armed with a bat when there's absolutely no supporting evidence of that whatsoever, including Officer Demario Johnson under oath in front of the Springfield Police Department, admitting that the call that went out was that Madison Greer's parents wouldn't let her leave the house. So they went through these extraordinary efforts to create this, as we put it, fake narrative that this minor had a bat outside of his house. And the only evidence that he did is their litigation inspired narratives. So I know I'm over my time, and if you don't have any more questions, I will thank you very much.
Ron, your time had expired. Do you have something very briefly in rebuttal?
Very briefly, Your Honor, I do believe that the situation, the officers were entitled to pursue Larry Anthony, and when he presented with a bat, that is what justified the entrance and the detention. Thank you.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement, and that concludes court's calendar for today. We are in recess.